All right, good morning, everyone. Welcome to the Bureau of Automotive Repairs Advisory Group meeting. This is our second quarterly meeting for the calendar year 2025. My name is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I'm happy to welcome all of you to our meeting today. Hope everyone's having a wonderful summer. It's been a nice one. For myself, in particular, been doing a lot of traveling of late, so really enjoying the time away from the office. Although there's been some things of late that had to get back to, and we have a fairly busy agenda without a public workshop today. Usually, as you know, we try to have a regulatory workshop on a regulation package that we are working on. But today, we are free of one. There's no packages that are in that period where we would need some feedback on. But I think it's likely we will have a regulatory workshop probably coming up in the fall. Excuse me, I misspoke earlier. I said it was our second quarterly meeting. It's our third quarter meeting for this year. We'll have our fourth and final one in October. I'm getting behind in the year here. I want to do a few introductions before we start with the agenda. We've got our moderator who is behind the scenes here, David Bowie. I'll probably be calling on him as we use the ability to have this virtual participation through WebEx. And of course, our webcaster, Bryce Penny, towards the back of the room. This meeting is being recorded, as you heard. So there'll be a copy of the entire meeting by the end of next week, most likely. And then, of course, we have Zach Richardson, who is you all know, he's our co-moderator for this and organizer and helps me all the time with keeping this group in order and doing the right things to make sure that we meet our obligations and requirements under law and so forth with open meetings and such. Let's do before we do a round of introductions of the advisory group members and get started with the agenda, I just wanted to introduce a couple of others in the room. The deputy chiefs at the Bureau of Automotive Repair, who I think you're all familiar with. There's just two today. One's on vacation. Linda Jansen, Licensing, Consumer Services, and Administration Division. And then Bill Thomas, who you all know, I should all know, Field Operations and Enforcement Division. And then Clay Leak is on vacation today. He is with Smog Check, Information Technology and such. And so he's missing out. All right, that's the introductions internally. And then I want to do some introductions of our advisory group members, and we will start. Please just introduce the name and the organization you're representing. Some of you are alternate members for the principal of the organization, so and it may not be a nameplate, so we'll make sure we get you properly identified. We'll start on the far right to me, Bud, if we would.
Hi, Bud Rice with the California Automotive Business Coalition.
Les Swizer with California New Car Dealers Association, standing in for Anthony Bento.
Good morning, Matt Webb with the Preventative Automotive Maintenance Association.
Good morning, Jack Molodanoff on behalf of the California Auto Body Association.
Good morning, Ruben Parra with California Automotive Teachers.
Good morning, I'm Dave Kusa with Automotive Service Councils of California.
Good morning, Tim Chang with the Auto Club of Southern California, in for Megan McKernan.
Good morning, Jeff Cox, Automotive Maintenance and Repair Association.
Thank you. I must be, what's going on? This seat's vacant today. I won't take it to, it's just a better view. Bud usually sits here. I've always got my, the wingman here, Dave Kusa, to assist, but we'll go to the advisory group members who are attending virtually. If we could, moderator, Mr. Bowie.
All right, let's hear from Dean first, please.
Good morning, Dean Schlingman from Specialty Equipment Market Association.
And Ryan next, please.
Good morning, everyone. Sorry I can't be there today. Ryan Perini with the California Automotive Wholesalers Association.
And that's all of our online participants.
If any others show up during the course of the meeting, feel free to let us know and we'll kindly do an introduction for them for the benefit of everyone.
Absolutely.
All right, thank you very much. Okay, without further ado, we'll get started with our agenda. And we have, as we always do, batting lead off, Holly Helsing with the Bureau's Executive Office, our Regulations Coordinator. As you might remember, we have two normally. One has left the Bureau for, I don't know, maybe more drier pastures. I don't know, in Texas, but Kayla Shelton, as you might remember, we said goodbye and bon voyage to her departure at the last meeting. So Holly is running solo here in the Regulations Coordinator capacity until we can fill the vacant position that was vacated by Ms. Shelton. So thank you, Holly, for coming today to give us an update on legislation and regulations that are before us and some that might have already been gone through the process and already been adopted.
Thank you. Good morning, everybody. Again, I'm Holly Helsing. I know most of you. And I will go ahead and get started with the legislation and regulations update. The first one is some important legislative dates. The legislature is currently in summer recess, which ends on August 18th. September 5th is the last day to amend bills on the floor. September 12th is the last day for each house to pass bills, and bills must be signed or vetoed by October 12th. And before continuing, I want to remind you that we try to provide the most current information on the slides and in my presentation, although given the nature of this process, hearing dates or bill summaries shown may not reflect the latest updates, so be sure to check online for the most current bill information. The next ones, this is a list of the bills we're tracking, and I will start with AB 987. And this bill would expand the list of presumptively unreasonable fees related to storage and towing to include storage fees for state holidays that exceed the standard posted daily rate, and towing fees charged when the owner is directed by a law enforcement officer to remove their vehicle at the scene of an emergency. This bill was re-referred to the next slide, though, please. This bill was re-referred to the Senate Appropriations Committee with a consent calendar recommendation, and that hearing is set for August 18th. The next slide is SB 1368. This bill would change the exception from the biennial inspection for vehicles manufactured prior to the 1976 model year to vehicles 30 or more model years old. However, in April, the first hearing was canceled at the request of the author. But we'll continue to see if that has any movement next year. SB 615 deals with the responsible end of life management of vehicle traction batteries if it is removed from a vehicle that is still in service or is offered a return to its battery supplier. This also may require reporting information to the Department of Toxic Substances. And this bill was re-referred to the Assembly Appropriations Committee on July 15th. The next one is SB 712. This would exempt vehicles from the smog check requirement if the vehicle was manufactured prior to the 1981 model year and has been assigned a special identification plate indicating that it is a historical vehicle and it is insured as a collector motor vehicle. This exemption would expand by one model year every 5 years, for 5 years, beginning January 1st, 2028. And this bill was re-referred to the Assembly Appropriations Committee on July 15th. The next one, SB 774, would extend the date of the citation and remedial training programs for ARDs from January 2026 to January 1, 2028. And this also was re-referred to the Assembly Appropriations Committee. This was on July 9th. The last one is SB 861, and this bill is a technical cleanup bill that would update cross references to the Business and Professions Code in relation to the vehicle safety systems, inspection stations, and technicians. On July 16th, this bill was passed by the Assembly Appropriations Committee and ordered to the consent calendar. And the last update was July 17th. It was ordered to a third reading. That's all I have for legislation. Does anyone have questions?
Yes, Mr. Kusa.
Thanks, Pat. Thank you, Holly. So Dave Kusa with ASCCA on 712, SB 712, the collector bill. So the 81 model year, was that this, didn't this one used to have like a 30-year roll? So they changed that? Okay. So yeah, and then I get that it'll move up over the next 5 years after that. But so currently model year 75 and older have no restrictions for, I mean, they're completely exempt. So do we know if this bill passes, would 75 and older have to have historical plates and insurance, or is it only 76 to 81 and then rolling up from there?
Pre-76, completely exempt. No,
Okay.
they don't have
So
to go
nothing
through a collector motor
Currently,
vehicle.
yeah, so nothing
No,
changes
same-
on that side.
Same,
Okay.
same as it is.
Pat and I are happy about that.
I don't have anything that old.
Yeah. Okay, that was my question. Thank you.
Yes, Mr. Rice, but
Just for clarification, Pat, for us here and
Yeah.
then those online, the legislation watch is an informational accommodation that you're giving the group here, but BAR does not take a position on legislation. Isn't that correct?
not unless we are given the authorization to do so, and we have not had a position that we've taken on any of the bills. So you are correct, sir. Thank you for pointing that out. We'll get to the audience in just a minute. Let's get to the advisory group first. Mr. Para.
I just have a quick question. What do we mean when we say re-refer to the assembly? What are they going to do with that when it's re-referred to the assembly?
I'm not the lobbyist in the room, so
Oh, there's a few.
the SB 712, there's several.
There are several here that
Yeah.
that are re-referred to the Assembly Appropriations Committee.
Well, it just means it's moving through the process.
It's moving through the process.
Yeah. It's still alive. Like, for example, if you go back to the bill, where it says AB 1368, it says there, the SEFR hearing canceled because that's not going anywhere. That's dead for the year. Yeah. The other ones are all the other bills are moving forward. And so it's just part of the process.
Okay.
They just go, to a particular committee, or technically if they get amended, they go to the floor and then they come back to committee. Yeah.
So it might be the second time that committee has seen the bill with changes.
But it doesn't clarify here where they're at. It just.
Yeah, this is just shorthand.
Okay.
Yeah.
But it's going through the process.
Okay. Thank you.
Excuse me, Jack, I thought that the Senate and the Assembly were two different houses.
They are.
So if it went to the Senate and the Senate did what they were supposed to do, then it would be sent back to the Assembly for action since the Senate has done their action.
All of these bills have been approved by the other house. And so now they're with
The second house,
Yeah.
yeah. Except for the one that kind of.
Oh, the one that,
the
yeah.
AB 1368, yeah, that one's kind of languishing in the first house and the first committee. Anybody else here on the dais? Any advisory group members who are participating via WebEx? Moderator, could we ask if the Mr. Schlingman or Mr. Perini or anyone else who might have shown up since we started the meeting have any questions. And then we'll open it up for public comments on this.
Right now, we have just the two of them. Neither of them have their hand up for comment. We'll give them just a second longer to see if they put their hand up. I think we're ready to move forward.
Was there a public comment? Yeah, please come forward so we can have you introduce yourself and ask your question or make your statement. Welcome. Good morning. There's a mic there. If you could lean into there and make sure we get you on the recording.
Hi, everybody. Christina Kubran through 52 Innovation. And as the proud owner of a 64 Ford that I built in college, I'm very happy to hear about that first part. But I can't help but wonder, what if the insurance company refuses to insure the car? Is there a process that the owner of the car can go through to remedy that situation, or other alternatives, or like give them a window to get it done? I don't know, but there's some.
Yeah, I'm not aware of that either, as you have pointed out with respect to, so your 64 vehicle is already exempt. It will be exempt going forward with or without this legislation. It's pre-76, but if you have a vehicle that's in this model year range that we're talking about from 1981 all the way up to, well, I think we've decided, if you do the math, I think it's 1980, 85 or 86, because it's a 5-year rolling from that point forward. Those vehicles don't get an automatic exemption. They have to qualify as a collector motor vehicle. The process to do that is through the Department of Motor Vehicles, issuing historic plates to these vehicles, and then proof, as you pointed out, proof that you've been insured for that vehicle with collector car insurance. We'll shorthand it. I do not know if there's an alternative. This bill does not have an alternate plan or a plan B if the insurance company does not issue the insurance. I'm not sure how hard or easy it is to get that insurance or what that entails in terms of proving that this is a collector motor vehicle and insured as such. Those details are going to have to be worked out after the bill is, and it does require regulations. Currently, as the bill is drafted, requires regulations to be adopted by the Bureau of Automotive Repair to determine that process. But we have not even gotten that far, obviously, because the bill's still going through the legislature.
Okay, because I was just, I'm up in Mendocino County, and there's a lot of people still driving around in old trucks and whatnot. And I was just thinking, if that's their only vehicle, and now the insurance company refuses to classify it as a collector, what are they going to do? So I'd hope they'd put something.
When you say old vehicle, they're driving around with an old vehicle. I just want to clarify.
Or like in your range.
In that range, beyond 76, it's newer than 76. It's 76 or newer.
Just kind of in general, but like if that's their only vehicle, maybe they're, struggling or whatever. And then if they have to go, they try to go through the process, and then the insurance company refuses to insure it because it's not very good condition, but it's the only one they have. Like, what are they supposed to do? So that's kind of what I was thinking.
My understanding would be that wouldn't necessarily qualify as a collector motor vehicle because the vehicle must be used for, and the way the legislation reads, I think current law is that it has to be used in shows and parades. I mean, seldom used vehicle.
The mileage
can't be like a daily use or.
My dad has several historical plates on his 51.
Yeah, so those are the vehicles that they're looking at, not a vehicle that might be an everyday use vehicle. So in that case.
But if it falls in that model year range, wouldn't it be forced into that historical plate for smog, or would they just continue to smog it?
Yeah, they would have to continue to smog it.
So that's the other option. Okay, that's good. Because that's what I was worried about. Thank you so much.
Yeah, you're welcome.
Actually, Pat, no vehicle should be on the road that can't be insured, right? So it doesn't matter what it is, but if it can't be insured, it shouldn't be on the road anyway.
Correct.
I think she was commenting on the historical,
Right.
Right. But so the concern is what happens to those cars, not that you just continue to, it's just like today, right? You would continue to be part of the smog program.
Right.
Yeah.
Absolutely correct. We'll open up for more public comment at the end of the presentation with the regulations. And if anyone wants to circle back on the legislative bills before us, we can do that as well. Please continue.
Okay, thank you. Now I'll go over our pending regulation packages and ones that have been approved this year. These are our regulation packages that have been adopted this year. There's been 2 Section 100s and the Omnibus Cleanup Bill, and all 3 of those update code sections and technical cleanup. Those 3 separate packages became effective in March, April, and May. Our tear down disclosure requirements for ARDs became effective on July 1st, and the smog check readiness monitor limits package was approved by OAL and will become effective on October 1st. These are 4 pending regulation packages, beginning with the mobile and referral ARDs. This proposes to, on the next slide, clarify the definition of mobile automotive repair. It adds a geographical radius for when automotive repair is considered mobile in relation to where the repair is performed. It adds that a person or entity is considered to be an ARD if they collect compensation for automotive repair services that are referred or sublet to another person or entity to perform. This package was submitted to OAL for final approval on July 9th. And we have an expected adoption date of October 1st of this year. The next one is the storage fees package. This brings together existing laws governing storage fees under one unified regulatory section. This provides that fees charged for the storage of a motor vehicle are reasonable, when storage fees may be charged, and where a vehicle may be stored. It also makes clear that an ARD must provide an itemized estimate and invoice for storage fees and post the towing and storage fees access notice, as well as their current daily storage fee rate, and provide that rate to the Bureau annually when they renew their registration. Next slide. This package also requires that the Bureau create a search tool on its website showing the average and median daily storage rates for a given locale. And it defines locale as one of 4 geographic radiuses around each reporting ARD that is sufficient to identify the average and median storage rates. We are in the process of working with DCA to submit this package to agency for approval to begin the 45-day public comment period. The next 2 packages are new to this bag presentation. The first one is the change of address requirements. And the purpose of this package is to remove inconsistencies and duplicative text in the current regulations. And this clarifies the timeframes for reporting material changes. Specifically, the time frame for a notice of change of address is 14 days, and notice of change of other material changes is 30 days. And this one, we are also in the process of working with DCA on this package. And our last package, again, which is also a new one, is to update the smog check manual and the vehicle safety systems inspection manual to add or newer to the permitted types of the biometric palm vein scanner model. This is so that as newer models become available, they may be used in addition to the originally listed model in those manuals. This one, we are in the process of working with DCA as well in the beginning stages. And that's what I have for regulations. Any questions?
Advisory group comments or questions? Nothing here. Moderator, anything from our advisory group members who are attending via WebEx?
No hands yet, but I do want to check on a Jeff with no last name. If Jeff with no last name happens to be Jeff Peavy, we'd like you to raise your hand and join the panel. We also have a request for public comment pending.
We'll get to that in just a moment. Is that Mr. Peavy?
Does not appear to be Mr. Peavy.
Okay. Yeah, advisory group member who we're thinking would be attending virtually. Another Jeff. Public comments from anyone here in the room on anything that Holly has presented today, regulations or legislation beyond what was already stated or commented on regarding the collector motor vehicle legislation. Okay, moderator, we'll open it up for public comment on this presentation.
All right. WebEx is open for public comment. If you'd like to make a comment, we ask you to raise your hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3. And for our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. And our first request is coming from Alyssa. Hold on just a moment, please. We're going to send you a request to unmute your microphone.
Good morning. Can you hear me?
Yes, go ahead, please.
Hello, my name's Elisa Lair. I'm with Johnny's Custom Auto Body in Gilroy, California. I think a few of you are familiar with who I am. I have some concerns in regards to the verbiage used in AB 981 in regards to the storage. You've adopted the Department of Insurance word reasonable. And that, since the inception of the Fair Claims Settlement Act, has been a point of contention. And I am literally having massive issues with that today. And Dave Edwards is familiar. Patrick, you're familiar. Bill's familiar. I have concerns about the word reasonable because that word has been weaponized continually by the insurance companies. Again, I know that these things are already gone further, but auto body shops are not storage units. I'm not a tow company. I'm not these things. I don't want cars to sit at my shop. And I think what you are still unaware of is insurance companies do not follow regulations. And it takes me weeks, even though I've prepared and provided within 24 hours an estimate showing a vehicle's totaled, they will play games for weeks. And then they're upset when they have a large storage bill. So I would like you to consider that. And I would like you to consider the word reasonable because it's factual that historically insurance companies are everything but. So those are some things that I'd like to bring up about that. And yeah, please consider readopting a different word. Thank you for hearing me.
Well, thank you for attending today, Alyssa. Alyssa, is it?
It's Elisa, but I'll forgive you.
Elisa, my pronunciation. Sorry about that. You'd mentioned a bill, AB 981, but I don't see it in our package.
987, my mistake. It's 987 for the storage.
7. I was thinking you were talking about our storage fees regulations package, but
yeah, there's that.
AB. Oh, okay. There's another bill, AB 987. Okay, I see what you're saying.
So that was just the one I grabbed. I apologize. I've been pretty deep in dealing with the Department of Insurance right now, so I'm just trying to get things taken care of, paid for fairly for the consumer, and be able to keep my shop open. And the paperwork requirement for a couple of these things in regards to the towing, it's asinine as it is. I fight for a daily basis to get the amount of money I need to keep my doors open. And we are not allowed to charge administrative fees where I'm 3, 4, 5 hours into delegating back and forth with an insurance company over coverages on behalf of consumer. And the requirement for us to create several repair orders for every time a truck comes in, if it comes in a wreck and I got to send it over to Tesla or whoever to get a recalibration or something else done and back. And it's insane the amount of paperwork that I don't get compensated for because I have insurance companies coming in and their reasonable labor rate surveys show that they've magically become $40 less an hour than what I actually need to stay open. So there's a lot of issue I think that the BAR does not understand in regards to how the DOI dysfunctions. And I just really don't think you guys are completely aware of how things actually work versus how they do work. Patrick and Bill, I've been, keeping you in the loop with a couple of claims that we've been dealing with, and I think that you can understand the fight that we fight. And I would hope that you would take those into consideration and see that it's not as clean cut as you believe it is.
I thank you for your comments. I would like to follow up with you outside of the meeting to talk about some of those reasonable or presumptively unreasonable fees that you say you aren't able to charge for. Because
I
there
would be
is
more than happy.
there is the, and we have stated this in our workshops on our regulations package about how you can overcome that presumptively unreasonable fee with evidence to the contrary, that you actually performed that service. So I don't want to dive into it or get too deep
More than
into it
happy to
in this
discuss it
meeting,
with
but
you later.
we should follow up with you, or we should have a discussion after the meeting, or later in the week or next week.
I'd greatly appreciate that, Patrick.
Can we get your information through you have it, we have it. Okay. Thank you, Elisa. Elisa.
Thank you, Patrick.
Yeah.
And that was our only request for comment online.
Very well. Thank you. Anybody else? Let's circle back. Okay. Thank you, Holly. Good job. All right. Our next presentation is on our continuous testing program pilot, the CTP. And here to give us an overview of that is the manager who oversees the bar audits and inspections branch at the Bureau of Automotive Repair. That's Michael Sacco. Good morning, Mike.
Good morning. All right.
You got it?
Yep.
Good. Welcome.
Thanks, Pat.
Yep.
As mentioned, Mike Sacco over the Audits and Inspections Branch. I'll be giving an overview of our continuous testing program pilot that operates within our government fleet unit. So a little bit of background. The pilot began in 2002. It's a voluntary pilot program open only to government agencies operating registration exempt vehicles. Agency participate in the program in lieu of biennial smog check inspections, and it includes the transmission of the OBD data information to BAR. The statutory authority, Health and Safety Code Section 44019, preliminary, basically all vehicles owned by public agencies require emissions testing. All effective public agencies must report to BAR. Health and Safety Code Section 4424A that authorizes BAR to investigate new technologies, which includes the role of OBD2 systems to detect emission defects. Health and Safety Section 4424.5D, which authorizes BAR to conduct a pilot program, and participation in the program may be in lieu of the emission inspections. Our current participation, approximately 150 government agencies. Again, it's only open to registration exempt vehicles, which currently is approximately 39,000 vehicles. And there are currently 5 telematics vendors. Some of the benefits to the agencies, it streamlines the annual reporting to BAR. It allows for closer monitoring of each agency's fleet. There's obviously a cost savings involved, and telematics solutions may have additional benefits to those agencies outside of just the transmittal of the smog check information. Some of the benefits to BAR, the data is used to evaluate OBD2 effectiveness. It streamlines our fleet reporting process, and it allows BAR to compile and maintain emissions data to assess the smog check program better. So the enrollment, agencies would complete and submit an enrollment application. They submit their vehicle inventory sheet, and all of the information must be correct, such as the VIN, BAR file number, make, model, et cetera, things like that. They provide BAR with the daily report from their telematics vendor, and then the procedures for that reporting may vary depending upon the vendor, such as setup, how their web's set up, how they group their vehicles, things of that nature. Some of the agency responsibilities, they need to work with the vendor in order to provide BAR with their daily smog check report. They must repair their emissions defect within a specified time frame and adhere to all other program requirements. So some of the agency or the participating vendors' responsibilities is, again, making sure that BAR has the ability to retrieve their smog check or their daily smog check performance report, comply with the conditions outlined in the data requirements, and then adhere to all other program requirements. So some of the next steps for this would be to develop regulations to establish a permanent program. That would include no changes to the scope of eligible vehicles. Hope to leverage technology to increase additional efficiencies, and then codify some standards for program compliance, and then codify the off-cycle repair requirements as well. And that concludes the presentation.
Thank you, Mike. I appreciate you coming before the advisory group to give us an overview. This has been something we've been running for many years and probably underneath most people's awareness or underneath the radar, so to speak. It's pretty low profile, but we are going to introduce, as Mike said, we're going to propose a package to convert it into a permanent program with more just tie down some of the requirements, reporting and such with the participating agencies and the vendors. So it's been a long, I always call it the never ending pilot. It's, you heard it.
43 years.
Pilots usually aren't intended to last that long, but it's been one of those, we've been studying it and having success running it, but there have been some challenges, and I think we'd like to overcome those by solidifying or codifying everything in a regulation package. So we kind of wanted to give you an overview of the program, the pilot, before we introduce this package, hopefully later this year. Any questions from the advisory group? Yes, Mr. Rice.
Just out of curiosity, has there been any data gathered, and is there a snapshot? Have we learned that what we think will happen with the monitoring and what the outcomes are matches up with what the assumptions were originally?
I'm not quite sure I understand. You mean the expectation of the data that we
the data. In other words, the cars that you tested, have they been following along with what you thought the outcomes, the OBD2 testing and the equipment that it's testing is lasting and is holding the regulations for, outcomes along with what you thought it was going to be? Or is this showing you that things aren't lasting as long as they should? The emissions are higher than we thought they would be, kind of a snapshot as to what the data has been telling.
That's probably a better question for engineering who delves through all of the data. But just from a general standpoint, I don't think the program would continue on if we were to see such issues with like a degradation of the vehicle as quickly. But the requirements of the vehicles, so if we do see a fault within the data, the requirements essentially as it stands right now is the vehicle must be repaired within 90 days. Not to mention the data requirements in order to satisfy the in lieu of smog check inspection is 30, not consecutive, but 30 days total within a year of clean data, meaning it must be in a passing condition for 30 days throughout that singular year, which, as you know, is considerably different from an industry where it just needs to be in good condition one day in a 2-year cycle. So the standards for it are significantly tighter in this.
Yeah, thank you for pointing that out. And it's really a 24/7 monitoring of the vehicle every day of the week, every month, every year. All right, Jeff Cox.
Jeff Cox, Automotive Maintenance Repair Association. So 39,000 vehicles are on the program today. Is like what percentage of the,
like the
park
fleet?
of, the
10%. There's approximately 400,000-ish government or registration exempt vehicles that we're aware of, and approximately 2,600 active public government agencies.
And is that number of 39,000, is that a targeted number that you had to run through this pilot, or is there a desire to bring more of that 400,000 into the program?
They're added continually. It's based on, so our relationship is solely with, BAR's relationship is solely with the public agency based off of 44019, which requires those vehicles and agencies to report to BAR and obtain smog inspections. But each agency has their own priorities in order to obtain a contract with a telematics vendor for whatever reason, and then ultimately enroll. We take necessary steps for public outreach purposes to advise them of the program, and then it's their prerogative whether or not to enroll or not. But over the last few years, it's become a lot more prevalent. Telematics has been employed by multiple agencies, the state of California, federal government, et cetera. And because of the advances in technology, it's slowly starting to build up even more over the last 5 or so years. So we expect it to just continually increase, which, like Pat said, which is why we're looking to more formalize the program.
Yeah, thank you.
I can't remember. It's obviously state agency fleets, and local government.
Mhm.
Any federal government agencies?
Yeah, so, well, the federal GSA, they have
Yeah.
a telematics contract vendor, and they have the ability to do the same.
Okay.
I'm not sure exactly how many federal agencies may be enrolled currently.
Yeah,
But
but it's across the board then. Okay.
yeah, anybody that operates a registration exempt vehicle.
Okay. Thank you. Mr. Kusa, and then we'll go to Mr. Parra.
Thanks, Matt. So I know we're going to look at regulations that won't change the scope of vehicle, but there are currently lots of independent insurance companies would be an example that use telematics reporting systems. Is there any future plan to outside of the proposed regulation to make this available to just, non-government vehicles, to my vehicle? Could I volunteer for this program sometime in the future or
Yeah,
mandate it?
I figured that'd probably be the primary question that
Yeah.
we would get asked. But from my standpoint, I'm not aware of any issues like that. And I would believe that that would require legislative action as well as additional input from some place like Air Resources Board or somewhat. But from my standpoint, this is just strictly a government fleet, and I'm not aware of any plans or whatnot to expand it out.
Thank you.
Mr. Parra.
Thank you. So this is kind of along the line of what Bud was asking. 23 years of data, that's a lot of data, right? You can study the effects of aging in that term. So what exactly we're doing with that data, and has there been change because of it? Have we learned something and changed the way the smog check program is run, the equipment used in the smog check program, or where could we find some of the data that would be interested to us, to the automotive industry, smog check particularly?
That's a little probably beyond the scope of the government fleet type unit, but I would defer that to engineering, who's essentially in charge of the data and the pass-fail criteria. But it's very similar to the data received during an OAS inspection. So there's almost no difference there. This is just relating to a telematics device transmitting the information from the vehicle, which includes all of the same parameters that we would receive from the OAS, and then internally make the pass-fail criteria based on the same criteria, if that makes sense.
So I assume that these tests are being done by government employees, not smog independent shops, or who's actually doing the inspections?
It's just a transfer of data. It's not an actual smog check. It's in lieu of the biennial smog check inspection. So it's just the wireless transmission of the OBD data from the vehicle directly to BAR. And then we look at all of the data, determine a pass-fail for that vehicle, and then inform the agency if there are issues. They require to obtain the repairs within 90 days in order to stay in the program. If the vehicle is removed from the CTP pilot, they just go revert back to obtaining their regular required smog check inspection, just like every other vehicle required to do. The difference is because it's registration exempt, there's no tie to, we won't register your vehicle until you get a smog. Since there isn't that, it requires BAR to continually monitor a public agency fleets to ensure they meet the same requirements as every other public vehicle on the road.
Okay. And is that data available to the public?
I believe so. Again, I would refer that to engineering, but I believe it would be available similar to how our regular smog check data is through PRA.
Thank you.
Thank you very much. Additional questions or comments from advisory group members? Anyone seeing none here, we'll go to the virtual attendees. Any BAR advisory group members who have a question or comment on this presentation or for Mr. Sacco?
This is the moderator. None of the advisory groups have, members have their hands up.
Okay, we will open it up for public comment, starting here in the room on this topic. Yeah, we did get a hand raised. Please come forward. Please. Welcome, and please introduce yourself for everyone. Yeah.
My name is Alan Chicos, concerned citizen. As far as PRA, what's the acronym for? Okay. Now, as far as engineering, is there a contact number or?
We'll put you in touch with, they're in the room here. We'll make sure that someone,
Okay, specifically, you got
reaches out to you.
over 2 decades of data compiled. Now, there should be an assessment there on, as far as, these are not electric vehicles, but they're exempt. Are they hybrid electric or?
No, exempt meaning that they are exempt from the registration process. So like
Okay.
paint-plated vehicles,
So they're-
be on a police car or an ambulance.
They're fuel vehicles. Okay, excuse me. My next question is on the different formulations of fuel that we've been through for the last 20 years. What the data show as far as taking out the sulfur content? Now we got more seal that needs to be replaced, all those compounding problems.
This is, the data received for the continuous testing is nearly identical to the data received from the OIS inspection being done on 2009 vehicles in 19.
Okay, so we should be able to see the numbers as far as,
It's not an emissions test, so it's not a tailpipe test. They don't.
oh, no,
measure
no,
anything from
I'm talking about the repairs that are needed. Some seasons you get repairs on O-rings, okay, injector pump seals and whatnot. Should we correlate that with your continuous testing program?
I don't believe that data exists in the open system.
Oh, okay, so that the continuous testing don't, so you guys are just basically, who confirms and verifies all the input for the last 20 years? Whatever your, no, the ones that are responsible for your parameters for the continuous testing program. I'm trying to understand this
So
program.
the telematics vendor is required for having the device.
Okay,
And that it transmit the data that we require it to transmit.
okay, now the person that's putting in the data to be transferred.
It's not putting in, it's done wirelessly. So it
Oh.
falls from the vehicle
Okay,
and gets sent. So typically what happens is like can't remember what the terminology is. It's like a cell phone card.
yeah,
So
okay.
something that you might put in your laptop, that's built into the telematics device and it transmits the data wirelessly.
Okay, so while it's on the road being utilized, you can,
Yeah, similarly, like I think somebody mentioned, insurance companies have been using like a dongle that you plug into the Bluetooth connector and it transmits the data so the insurance company can see certain parameters.
okay, just take the human element out. Okay, all right.
Yeah, so it's not a manual process where somebody pulls information from the vehicle, punches it in, sends it that way.
Okay.
Yeah, it's all done.
Sorry, I'm old school.
No worries.
That's 1977 was mine. Okay. So then it's through the public reporting. All right. Okay, clear. Have you guys talked about the consumer assistance program yet?
It's not on the agenda today, but there will be a period at which you can comment on anything that's not on the agenda.
Okay.
That'll be toward the end of the meeting, but appreciate you if you could just wait until then
Yeah.
to add some input on that.
Thank you.
You bet. Yeah.
Thank you so much for being here today. Any other comments from the audience here in the room? Moderator, could we open it up for public comments on this presentation?
WebEx is open for public comment. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. As a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to wait just a few more seconds to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, thank you. We can close out that public comment. All right, good job.
Thanks.
Thank you, Mike. All right, our next presentation is on our newly adopted and regulations that have taken effect as of July 1. Dealing with automotive repair dealer or ARD tear down and disclosure requirements. And here to give that presentation is Matthew Gibson with the Bureau's Field Operations and Enforcement Division. And here to assist him, is Bill Thomas, our Deputy Chief for Field Operations and Enforcement.
I'm here to occupy the seat.
Oh, okay. So we don't get any public comment, or is that what you're doing? Good job. I like it. You might have to do one of these seats up here. All right. Thank you for being here.
Well, thank you, Pat. Again, I'm Matthew Gibson. I'm Program Manager with the Field Operations and Enforcement Division, and I'm here to do a presentation on our new ARD teardown and disclosure requirement regulations. Oh, you already got it there. Look at you, Zach. Okay, here we go. So I'm just going to point out that teardown regulations are not new. They've been in the Automotive Repair Act since 1978. They allow an automotive repair dealer to completely disassemble a component like an engine and provide one itemized estimate to completely repair that component. Instead of the alternative being that you have a repair facility that would end up giving a consumer continual estimate revisions as they tear into the component, as they find problems, where a consumer might not even be able to afford the repairs at the point that the engine is becoming disassembled. And so given that we have this tool, for some time, BAR has been encouraging the collision repair industry to use teardown estimates for collision repairs. So in collision repairs, a teardown estimate requires disassembly of a vehicle to a point where the automotive repair dealer can identify the extent of the collision damage. And it requires generation of an itemized estimate to restore the vehicle to its pre-loss condition. When preparing an estimate for a vehicle with a high potential for hidden damage, and so obviously hidden damage, we're talking about damage that's below the surface that you cannot see without disassembling in this case, the vehicle. A teardown estimate can be beneficial by reducing or eliminating supplemental estimate revisions, resulting in faster repair times. It'd be beneficial by providing consumers with more realistic time frame for repair processes, and avoiding a vehicle being deemed a total loss after the repair facility has performed a lot of or extensive collision repairs and thousands of dollars, and then in the repair process finds hidden damage, again, which causes the vehicle to become a total loss. That scenario comes up in consumer complaints related to collision repairs frequently and is bad for everybody who's involved. So anyway, okay, the next slide. Oh, you already got it. Look at you. So our new disclosure requirements. Here's an overview of what's in the new teardown disclosure regulations. So the following new,
going way too fast here. There you go.
All right. So the teardown regulation, disclosure regulations include the following new estimate and authorization requirements. It requires a general description of the area of the vehicle that is to be disassembled as part of a teardown. It requires an automotive repair dealer to record additional information on their estimate when adopting a third-party payer estimate as the method of repair. It requires the customer to be informed of the amount accrued to be paid by the third-party payer when that amount is known. And it requires towing services to be documented on a separate form from the repair estimate or invoice. Okay, the next slide. So starting with the teardown estimates, the regulations make clear that a teardown estimate is a repair as defined in Business and Professions Code Section 9880.1K. We felt it was necessary after some prior workshops on other proposed regulations to clarify this because there seemed to be some confusion about that point. The regulations require an ARD to provide a description of the portion or area of the vehicle that will be disassembled as part of the teardown estimate. that description itself doesn't have to be itemized. I'm not expecting, or we wouldn't expect that you as a collision repair facility would lay out or list out every single component of the vehicle that you're going to disassemble as part of the teardown. But conversely, we also would expect that you give more of a description than the area of damage. That wouldn't be sufficient. So for example, if the vehicle was involved in a rear end collision, the description we would expect is something along the lines of that the portion of the vehicle is going to be disassembled is the rear portion of the vehicle. If it was the front, if it was in a front end collision, same thing. We would expect that the description would be that you're going to disassemble the front end of the vehicle. And this is consistent with how the section is applied in other areas of automotive repair. The regulations still require an ARD to provide a teardown estimate to include the cost of and maximum time to reassemble the vehicle or components, including the cost to replace parts normally destroyed during the teardown. Because again, these teardown regulations apply to all areas of automotive repair, not just, well, we're talking about collision primarily, but it applies to all areas of automotive repair. And the estimate needs to include a notification that the teardown may, or in the case of collision repair, will prevent the restoration of the vehicle or component to the condition that it was when it was delivered to the automotive repair shop. And I get the next slide, Zach. So here is an example that I don't know that you'll be able to see. It's okay. Of the kind of description we're talking about. This is actually out of the Right or Right booklet. I'll get to that on the last slide of the presentation. But the point is that in the description, it says disassemble the right front exterior portion of the vehicle to assess damage and prepare an estimate to repair. Disassembly will prevent restoration of the vehicle to its current condition. So that's the kind of description that we're talking about. Can I get the next slide, Zach? Oh, do you have something, Bill? Hold on, let me
Want to make myself useful here. Note the yellow part on this sample, and there's another one in the right at right, is a note for ARDs and not something that's expected to be on an estimate or invoice.
All right, thanks.
Can we read that? What is that note? Can't read it really on our hard copy either.
Well, here, you get better eyes than we do.
Let me fix that real quick. So no.
I think you might be able to read it from the screen better.
If reassembling the vehicle indicate the maximum number of days needed from the date of the teardown authorization, always specify whether any portion of the teardown process will be sublet. The teardown is only complete after providing the customer with an itemized repair estimate. That's what the note is.
Yeah, perfect.
It's really a tip, right?
Yeah, it's just a tip. Well.
Oh,
well, it's more than it.
I should have just read it from there.
Yeah.
All right. Anyway, can I get the next slide, Zach?
Yeah. All right.
All right. So I will just reiterate, as I did on the first slide, the BAR encourages collision repair facilities to perform teardown estimates to generate one itemized estimate to restore the vehicle to a pre-loss condition. There is no requirement for an ARD to accept or adopt a third-party payer estimate as the method of repair. But if they do, they shall record that fact on their estimate and include the name of the third-party payer, the provided unique identifier, and that is a number, theoretically a number that is contained on that document, such as the claim number, the work file ID number, or an estimate number that's unique to that document. And they must include the total estimated cost of repair. They shall attach that third-party payer estimate to the ARD estimate that they provide to the customer. They shall notify the customer that the third-party payer estimate is subject to the California Department of Insurance's Fair Claim Settlement Practice regulations, and those two sections that are listed there. Yeah, you can see them. Refer to the standards applicable to the automobile insurance so standards applicable to automobile insurance and also the auto body repair consumer bill of rights. The ARD shall notify the third party payer of any customer authorized changes that alter the estimated payment amount. And the ARD shall comply with authorization requirements pursuant to California Code of Regulations 3354A and B, which have to do with obtaining additional authorization if you're going to exceed the original estimate and revising an itemized work order. Now, Zach, can I go to number 8, slide number 8? There we go. So here is an example of such a situation where a repair facility would adopt the third-party payer's estimate as the method of repair. And on the right-hand side would be the third-party payer estimate. And on the right-hand side in the description box, it says repair per attached estimate from ABC Insurance Company. It lays out the claim number and also the work file ID number. And then it has a note there that says the third-party estimates are subject to the California Department of Insurance Fair Claim Settlement Practices Acts. And it lays out those two sections that I just described on the prior slide. Now, to make sure that I cover all the stuff we did on the last one, there's a note there for ARDs.
Can you blow that up, Zach, please? The note? Yeah. So people can see that. I think it'll be easier than trying to read our hard copy. I can't even read it.
No, that's good.
Yeah, that's pretty good. Yeah.
Oh, if the customer authorizes any change that would alter the method of repair and ultimately the cost of repair, the third-party payer, insurance company, must be notified prior to continuing with the repairs. And then it has 3351 B1E of the California Code of Regulations. Additionally, customers' notification and authorization must be obtained and documented as required in 3354 A and B. In the estimate total sections, additional customer pay, I mean, we're not talking about that, but if you look on the right-hand side of the example, there's a box that says additional customer pay. Refers to out-of-pocket costs beyond the deductible, which are listed on the third-party payer estimate as the responsibility of the customer. We're talking about betterment issues such as tires or batteries, something that might get destroyed, but that does not get fully reimbursed by the insurance company. All right. Can we go back to number 7?
With these slides out of order, we need to,
Yeah.
okay, we'll fix them on the, after the meeting.
All righty. So if an ARD will be accepting payment for repairs from a third-party payer, prior to obtaining customer authorization, they shall record the amount approved to be paid by the third-party payer on their estimate when that amount is known. And this is consistent with other types of insurance like dental insurance or vision insurance. When I go to the optometrist, they're more than happy to tell me how much my insurance will pay for my frames or my lenses. And if I want something that they won't cover, they're more than happy to tell me how much I'm going to have to pay out of my pocket for those things that I want. But okay, so an ARD shall also, if they are not in a situation where they know the amount, inform the customer that it's their responsibility to contact the third-party payer for approval of payments for authorized repairs. Again, when that amount is unknown, by recording the following statement on the estimate. This estimate is for repairs that meet vehicle manufacturer and industry standards. As the customer, it is your responsibility to contact the third-party payer for payment of the repairs you have authorized. All right. Go to 9. Providing, okay, so although towing a vehicle is automotive repair related, it is not automotive repair. Authorization and documentation requirements regarding towing services are contained in part in Vehicle Code Section 22651.07. And those requirements do not meet BAR's estimates and invoice requirements, and nor do they have to. When an ARD directly provides or contracts for towing services for their customers, they shall provide the customer with the towing fees in an electronic or printed document. That document does not have to meet BAR's estimate or invoicing requirements. That document must be separate from the repair estimate or invoice, and that's pursuant to Vehicle Code Section 22651.07E. And they shall obtain authorization for towing fees separate and apart, and there's a typo there, it should be from, as opposed to for. Anyway, apart from any authorization for repair work. So as is always with automotive repair, if you're going to spend your customer's money, you have to have their authorization. But in the case of towing services, that authorization does not need to be recorded pursuant to the Bureau's authorization requirements. And one other thing I'll point out about this particular provision that's within the regulations is that this has been in the guidance that's been on BAR's website since January of 2024. All right, can I get the next slide? Maybe. All right. BAR has updated the right-of-right guide to help automotive repair dealers with the new teardown and disclosure requirements. The revised guide includes simple questions and answers, updated definitions, and new samples, including the ones that I shared with you today. And you can find that guide at the address that is on the screen. And that's what I got.
Very good, Matt. Thank you very much for doing this. That's very helpful to everyone here in the room. I'm sure there's going to be some questions or comments. Bill, thank you for the assist here of Matt. But there's questions and comments that are probably forthcoming, so I'm sure you guys can take turns answering those questions as needed. Any questions from the advisory group members sitting here?
Anyone else?
Anyone else? Anyone? How about, no, I'm kidding. Jack, yes.
Jack Miladonov on behalf of the California Auto Body Association. Thanks for the presentation, Matt. I really want to focus on the towing language because that's the one I have received a lot of calls on. And maybe part of the problem is that, you know, this is referred to as a tear down disclosure and requirements. So, you know, the towing is kind of tucked in there, but it's significant. Okay. Because now, well, in the past, I guess before July 1st, you know, if you had it's basically a sublet tow, you would document it on the estimate. You'd have one set of documentation. Now, this regulation proposes to create a separate set or separate transaction. So you're going to have two pieces of paper, right? And so, and maybe three pieces of paper. We'll talk about that later. But so we're creating more work for and cumbersome for the shop. And I think more confusion for the consumer because we're creating more paperwork. And so the first question I got is, what was broken? Why are we doing this?
As we were reviewing the vehicle code sections that the statute authorized us to look at and point to when creating storage regs, we recognized that this requirement existed in the vehicle code and that, quite honestly, we hadn't accounted for it in any regulations to date. And that since 2009, when that provision first appeared in the vehicle code, putting it on that document as a sublet was inconsistent with what the statute requires. E in the towing notice, and because it is in statute, it is law, says quite specifically about halfway down, says any estimate for towing shall be separate from any estimate for repairs. And so to enable our licensees to be in compliance with the vehicle code, we inserted it here. But I want to reiterate what Matt said. It doesn't create a burden. That estimate and then subsequently an invoice is not subject to the Automotive Repair Act. And so therefore it could be a phone call and it says, Jack, do you authorize me to tow your vehicle for $200? And you say, yes, great. When you get here, I'll give you an invoice for that. And I'll hand you an invoice for $200. Don't have to record the time, date, and any of the information that was related to that call as you would be required to do for an automotive repair transaction. And it just really, and we also want to, as automotive repair transactions become more complex, when our representatives are investigating a complaint or looking into a complaint to try and resolve what took place during the transaction, we don't really want to have to deal with the towing because, as Matt said, it's automotive repair related, but it is not automotive repair. And if you were to include it as part of an estimate, which is not allowed by the vehicle code, it all of a sudden brings into questions as to what took place when, what was the timeline of events. If the towing was authorized first and it's part of the estimate that's for the repairs, well, that now becomes the initial estimate and any future revisions are additional repairs. And it really seems to uncomplicate things as opposed to complicate things because it just peels it out of there and allows it to be dealt with separately as intended by the vehicle code.
Okay, I need to follow up on that because I got to push back on the statute and where this came from because do you have the reference of the section we're referring to now, the vehicle code section?
I think it's in the Consumer Bill of Rights notice.
Yes.
Yeah.
Okay, because I have it in front of me here, and I'm going to read parts of it because the section you're referring to is a notice. Okay. And these notices that were put in the statute are really dummied down, okay, for consumers. It's not really written in a really legalese. And and the statute you referred to, E, the section E of 22-651.07 it says that the towing and storage fees notice, and it describes the notice. And in that notice, it starts off, it says, note, the following information is intended to serve as a general summary of some of the laws that provide vehicle owners certain rights when their vehicle is towed. It is not intended to summarize all the laws that may be applicable, nor is it intended to fully and completely state the entire law in any area listed. Please review the applicable California code for definitive statement of law in your particular situation. So it has a disclaimer saying, don't rely on this. That's the way I read it. Let me finish. And so you're going, then in the notice, and I've got it in front of me, and it's a notice because it's dummied down for, for a sixth grader or seventh grader because it's going to the consumer, right? And it talks about where you can complain on the towing company. It talks about, you're entitled to receive an invoice of actual charges. You pay cash, a valid credit card. It gives good information from the consumer. I'm not saying the notice is inappropriate, but in this section, I think what you're referring to, it says prior to your vehicle being repaired, okay, it has two sections in here. It says you have the right to choose a repair facility and to have no repairs made to your vehicle unless you authorize them in writing. Fair enough. And then the second section, I think this is where you guys, the BAR was relying on. It says any authorization you sign for towing and any authorization you sign for repair must be in a separate form. I think that's what you're referring to. It doesn't say here you can't list it. The form can't be the estimate. It doesn't say that. Somehow you're interpreting the section of the notice. And by the way, it talks about towing, a separate form, and authorization. And it's interesting how you pick towing to make a separate form, but not the authorization. Because if you follow this consistently, you'd have to have a separate form for authorization. And the authorization is written on the estimate. I guess my point is that for some reason, I'm not sure there was an interpretation made that you need separate documentation for a towing. And nowhere does it say here that I read, in my opinion, that you can't just the form can't be just the estimate. You can't document that sublet tow and keep it to one document in the estimate, in other words. So you can document the authorization for the tow in the estimate like we've been doing for many years, or like shops have been doing for many years. So I wanted to bring that, and I wanted to challenge the authorization here, because I think it's not based on a statute. It's based on a notice that's been dummied down for sixth or seventh graders.
Have you reached out to the Office of Administrative Law and asked this question? Since they did adopt it back in whatever it was, May 29th. There's certainly a process to review regulation that's on the books, one that's even recently adopted, I presume, and ask that question. We have not yet. Obviously, we weren't aware of this being an issue until a day or two ago. So yeah, we obviously thought it would be something that would be well received. I'm almost concerned that it's something Bill was kind of alluding to. You want to bring this into the Automotive Repair Act? Are you kidding? I'm almost thinking that might we have not done a service to the Automotive Repair Act by doing all of the things, by including that, allowing that inclusion on a repair estimate. There might be additional regulations that would be required in a different fashion that might be more onerous that we have if you're allowing that to be included in the estimate and the invoice of an automotive repair transaction.
I just wanted to raise that issue.
No, I get it.
Yeah, I just wanted to raise the issue because when I looked at it, and by the way, when this came up, this was not in the 45-day comment period. It was sort of slipped in there at the last minute during the 15-day period and didn't give a lot of opportunity for comment, although I did comment on this in this provision.
Yeah, it was appearing in our storage fees, our proposed storage fee regulations package, I believe. And so it was out there in the public arena and never gotten any comments on it. And we were advised that it was not the appropriate package from legal counsel to be in that package. So we said, well, the most obvious one that's dealing with estimates and invoices is our tear down package.
Okay. Let's move to the practical.
I just wanted to see if Bill had
oh, I'm sorry.
piggyback on anything I had said.
I do want to piggyback on what Pat said, because as always, he makes an excellent point. If we were to include, as you say, an analysis of the entire 22,651.07.
I'm not advocating for that. So I just want to make sure that's not what
I heard you out, but
yeah.
so
No, I'll let you speak. I just want to make sure that's not what I said.
Well, you asked for a complete analysis of all the laws that are applicable. So we could go down to subsection G, which describes what an itemized invoice is for towing. And if we were to put this in regulation, we would be obligated to put all those 13 requirements for that invoice into regulation. So I think the point Pat's making is we honestly did think we were actually making this easier and less complex by just saying, do it on a separate. Honestly, and I say this completely facetiously, I don't think anybody in this room or on the call would do this as a business practice. But if you write it on a sticky note, it's not within our jurisdiction. And so we thought we were making it less complex. And I think you're probably right. We might need to, one, confer with the Office of Administrative Law and see if we missed the mark on the interpretation. I would argue that the disclaimer at the outset says this is not a complete. It doesn't say this is an inaccurate or a summary. It says there may be more aspects to this in addition to what's printed here, but what's printed there is law. And certainly we could take a look at and start workshops. And do we need an entire towing section?
I don't think we do. I think it should be, in my opinion, that section should not have been included in here and should be deleted or fixed at a minimum. But let's move on to the.
And I apologize that I did get in on this, but I'm just going to do real quick, which is that you are not actually subletting a tow because it's not a repair. So it's just an expense for moving the vehicle from one location to the other. So if you've been calling it a sublet, then in fact, we might have been mislabeling it if that wasn't the case. All right, that was it.
Let's talk about the practical aspects. So when a shop, whether collision repair or mechanical, customer calls and says, hey, my car's broken down. I want you to tow it in. I don't have AAA or, another car club. So at that point, what you're saying that cannot be included in the estimate, the documentation of the authorization. It has to be included on a separate form. Is that so separate documentation?
You would not have, there's no requirement for there to be a separate estimate or a separate form. That can be a verbal agreement between, all the vehicle code requires is a separate invoice at the end of the transaction for the towing. And so there doesn't have to be an estimate with documented authorization as is required by the Automotive Repair Act for automotive repair. None of that has to be documented.
So how does the I guess I'm just trying to understand, how does the shop document that? They have to, you're saying that they have to create it's a separate transaction.
Yes.
Okay.
But it's a separate invoice. And that transaction is not subject to the Automotive Repair Act.
Okay, that's fine, but they have to.
It could be on 3-part carbon.
So we've got
down on a piece of blank paper.
We got one transaction for the tow. Now, when the vehicle comes in, they're going to do a separate transaction, now an estimate for the repair, right? So we got two sets of documents.
An automotive repair transaction subject to all the requirements of the business.
Right. So they got two separate regulations. What I'm saying is they got two separate transactions, right? Instead of one, because normally, before July 1st, they would document this on the estimate. That's my point, that it's cumbersome because we're creating more paperwork now because you've got two separate transactions. That's my point. Right?
Oh, no. I agree. That's your point.
Okay. I like that. So then let's just follow it through. So you got two sets of two transactions now, and I'm assuming, but let's just follow it through. So the vehicle's in there. and the shop determines they have to maybe send it out for an alignment, okay, or calibration. They've got to get now authorization from the customer, and now that's a third transaction.
So to work off your scenario, it's on the, you have to start from the assumption that the car is not going to move under its own power.
Correct. It's got to be towed.
So it has to be towed?
Yeah.
All right. So that would be literally moving the vehicle from your ARD to another facility to perform a repair?
Correct.
And so you'd have to get authorization because we require a facility to get authorization when they sublet the repair to another shop.
Right.
But the tow is not a repair. So you could make, you don't really, we're not asking you to get additional authorization for the tow because it's part of the sublet and it should just be included in the cost for the sublet.
So on that one, you are, based on the language of the towing language, you are contracting with the tow company, right? So that triggers that, right? You're contracting with the tow company to get the car towed to the sublet. That's what you're doing, right?
Yes.
Okay. So then but based on your regulations, isn't that another separate transaction?
No, the transaction would be the sublet. So from our perspective, you wouldn't have to get another authorization to move the car from your facility to another
So
facility.
you can so I just want to make sure I'm clear. So you can document that tow, right, on the estimate now. You're saying that that's okay because it's a sublet?
It is part of the sublet. It's actually transporting the vehicle between the repair facility for purposes of sublet. So yes, I know we're splitting hairs. And again, that points to maybe we need a new workshop and more regulations. Yay.
We need less regulations. We don't need more. But I'm just trying to understand because I've gotten that question.
Yeah.
And I'm not being facetious. I'm just saying that the way, my hypothetical, you got one transaction in the beginning for the tow. The car comes in, you got a second transaction for the repair. Now, if you sublet it out and it's got to be towed, then you got a third transaction. That's the point of all this cumbersome paperwork.
I think that's a bit of an overreach in the interpretation. And I think the initial tow, because at the time you have the vehicle towed, when a customer calls you up and says, I need the vehicle towed to my shop, you haven't begun a repair transaction at that point. And so keeping it separate from the repair transaction as per the vehicle code seems reasonable and logical. And as we were advised in the crafting of these regs that we needed to address this, and transporting the vehicle to the sublet facility for the purposes of sublet, as Matt said, is part of the repair process. It is repair. The sublet is a repair and you're transporting it to it. So there's no, and maybe say it better, but there's no, at the initial tow, there's no agreement and commitment and contract to repair the vehicle. And therefore, keeping it separate from that repair transaction seems consistent with what the statute requires. Once you're repairing the vehicle, now you have to make arrangements to have the sublet performed and to get the vehicle to the second facility. So it's more of it's not the purposes of removing the vehicle from the roadway or from a consumer's residence or anything like that. It's the purposes of continuing with the repair transaction. And it's part of the authorization for that.
Okay, I'm not crystal clear on that, but I mean.
Well, let me help. The answer is, yeah, no, is the answer.
So you don't need a separate form on that sublet if it's towed, even if you contract, which is inconsistent. I mean, I just want to make sure because that's what the regulation says. If you contract with the tow, and that's what the shop will be doing, and you're telling me right now you don't need to do another form there because it's a sublet for a repair.
It's a good question. It's a good question. And it's not addressed.
It is,
and I think,
that's why.
And I think our interpretation is no, but maybe it needs clarification.
Okay. Okay, good. Okay. I appreciate that. So that's, okay. I agree. It needs to be addressed because there is a lot of, clarity that needs to go into these, into the towing aspect. Let me jump to, the adopting the third-party estimates for the insurance companies. I know you allow for it. I know that the association, or at least my recommendation is, don't adopt a third-party estimate as yours. Create your own estimate. Because once you adopt a third-party estimate, you're not doing you're not even diagnosing. It's like a doctor, adopting the insurance company diagnosis on you. It's like the doctor doesn't even do a diagnosis. So we discourage that. And I hope that BAR, as the best practices, would encourage shops to create their own estimate and not adopt third-party estimates as their own. I don't know.
I think Matt said that at the outset of his presentation, that we encourage tear downs and proper diagnosis and or inspection and estimate.
All right.
And however, this is not including CAA members, California Auto Body Association members. This is a very common practice, and we weren't in a position at this time to just discontinue that practice as a whole. However, how BAR has seen it in countless complaints, easily in the 4 digits, probably in the 5-digit complaints over the last decade or so. We see a lot when we go to a repair facility in a consumer complaint or in a no-cost auto body inspection program inspection. We ask for the estimate and invoice, and the repair facility hands us the third-party estimate of record and says, and we're like, this is what you've got? And they said, yep, that's what we repaired the vehicle per, and that's our estimate, that's our invoice, that's everything. It happens countless times on a daily, weekly, monthly basis. And we would agree, it's not a good business practice, but nor are we in a position to completely cancel it at this point. Maybe in the future, but.
Okay. And my last question is on the third-party payment disclosure. So if the shop knows what the insurance company is going to pay, so the consumer say a collision repair facility, they walk in with a check, right, from the insurance company. So for the shop to be compliant, because they see the check, all they have to do, they have to disclose on there that, customer gave me a check of, $1,500, let's say, for example. That would satisfy that requirement?
Yes.
Okay.
I think in the crafting of those regs, we have to account for that circumstance, because there are circumstances where the repair facility completes the estimate and knows what the insurance company is going to cover. They know actually in maybe through contractual agreements, prior experience or whatever, they know that the insurance company is only going to charge the consumer the deductible, and everything else should be covered by the policy or will be covered by the policy. And so they know to subtract $500,000, whatever the deductible is, and the insurance company will likely pay the rest. However, I think it's safe to say we envision that in most cases, especially if the repair facility is doing the best practice in the industry and doing their own tear down, disassembly, and estimate, the amount the insurance company is going to pay is not known. And just even if there's a preliminary estimate, and let's just say it's $10,000 and there's a $1,000 deductible, so the insurer is going to pay $9,000. But the ARD does a second tear down further inspection, and they have a $15,000 estimate. The insurance company's commitment or agreement or perceived responsibility of $9,000 is really no longer valid, because it's based upon an estimate that's incomplete. And so we would expect in that circumstance that the correct verbiage is the second verbiage of the second part of that section, which is this vehicle. And really, that's probably the best practice in most cases. Is this estimate is to repair the vehicle to manufacturer and industry standards. It is the customer's responsibility to check with the insurance company. I will say a continued best practice, a good business practice, but we couldn't put it in regulation, is always to offer and assist your consumer and your customer with navigating that transaction and with the insurance company. But at the end of the day, and the fair claim settlement practices require this too, once a repair facility provides a separate estimate, the insurer's responsibility is to notify the consumer, the insured, of proposed changes to that estimate, and not the repair facilities. We're all too often we're seeing in a lot of these transactions where the shop and the insurers are negotiating the total repair cost and only informing the consumer once a decision and agreement has been made. And that's not how the process is codified in our regulations, our Department of Insurance regulations.
Let me just go follow up with my example here. So the customer comes in with a $1,500 check. I know that as the shop acknowledges that, and they write an estimate for $2,500. So there's a gap of 1,000, right? So in order for the shop to be compliant, all they need to do is put down that they got a check for, for $1,500. Third party pays $1,500. They don't need to go further and say, oh, by the way, you're going to owe $1,000. Do they have to go that far, or they just disclose that they received a check or the payer was going to pay $1,500?
So as we know, the insurance company is not the customer and cannot authorize repairs. The only person who can authorize the repairs is the customer.
Correct.
And if you know that the insurance company is going to pay less than the amount that is estimated for, then yeah, you have to get authorization from the customer for that amount. And then they know that $1,500 in your scenario will be covered by the insurance company and they would be responsible for the rest of it.
Yeah. So I guess I'm just talking about the disclosure, what you put down on the estimate there, that you received a check for $1,500 from the insurance company, and that satisfies the requirement. I just want to make sure.
There was an example where you had additional consumer copay or something like that.
Yeah, that's for betterment or something like that. That's,
my apologies.
Yeah.
In your example, I don't think the $1,500 would even be referenced. It would be the second half of that regulation of this estimate is to repair the vehicle properly.
Oh, you're saying the disclosure statement?
Yeah, the disclosure statement, and then the check can be used as payment towards the cost of repairs, because that amount is sort of moot at that point, because the overall estimate, regardless of who pays for it, has now changed. And so that value is invalid. It certainly can be used as part of the payment towards the repairs, but there's a shortfall that has to be made up. And I don't know that we're going to require ARDs to list on every estimate. Well, you've got 5 checks in this amount.
Okay.
So.
Well, I just want to make sure, because it sounds like this disclaimer statement, in my opinion, now as a best practice should be included in every estimate, especially, just included in there to cover the shop. So because, revisions are made and so forth. And if this statement is in there, it protects the shop and it discloses to the consumer, you better check with your insurance company on the amount paid.
We didn't include that as an absolute requirement in the regulations, but I don't know that that would be discouraged in any way.
Yeah. Okay. Thank you. Those were my questions.
Thank you, Jeff. All right. Let's move to others. Can I go to, and then I'll go. I saw him first. Sorry. I know. How's that possible? You're sitting right next to me.
Well, when you were ignoring Jack, by default, you ignored Dave as well. Exactly.
Go ahead.
Okay, thank you. As I'm listening to this back and forth thing going on here, I have to be honest and tell you guys, when April of next year rolls around, I've been in the field working for 50 years. Okay, 50 years. And my teaching of people has always been the invoice tells the story. And everything that happens with that car, with that customer, is to be reflected on the invoice, everything. Okay, so at the point where a customer wants to have their car brought into the shop, if they do it and they paid for it, it's not part of my story yet. Okay, if I have to call the tow guy and have her car towed to my shop, it is part of the story. And everything that goes along with that is in the invoice. Okay, and at the point where there's a credit, it's a line item. This is what's left to pay. It's a line item, but the whole story is lined up over here. But telling people they got to go find 3 different work orders and tie them together with a unique identifier and hoping that it's in your invoice box, that if somebody comes in from bar, you can figure it out how to put the pieces back together again. I teach the work order tells the story, and everything that goes along with that interaction with that customer is on that invoice. So everybody can follow the story from beginning to end. And that's what I think ought to happen here. It ought to be the full story on the invoice for the customer's approval, authorization,
done, and we're done. Thank you for the comment. We're not going to be asking for the towing invoice. It's not automotive repair. And the vehicle code it says what it says. Whether that interpretation is correct or not, I think that's future questions to be answered. But
Thank you, Bud. And moving to Dave Kusa.
Thanks, Pat. Thanks, guys. So, beating the towing a little bit more. So,
I suspect we're going to get a lot of that.
yeah, so I get what you're saying, right? You know, I contract the tow company. We have no repair event yet. Car's dead on the road. Car comes to me. I have a separate invoice. Bart is not interested in what that says. I'll circle back to that in a second. Jack's scenario of, okay, I've made a repair to the car's not drivable. I need to tow it to a third party as a sublet. So I'm going to list the tow because as I understand sublet rules, I have to disclose who is subletting the repair, right? And who I'm taking it to. I can't keep that secret from the consumer. So don't I need to therefore disclose to the consumer that I'm arranging for a tow, which I'm going to charge for as part of that sublet. It's going to be a separate line item, right? Because from an accounting standpoint, I'm going to do it that way. Otherwise, nobody knows what happens. So when the consumer says, Dave said the tow was $100, but he charged me $150, I'm complaining to BAR on the sublet portion of it. Are you going to say, Dave, we have to talk? Are you going to say, too bad, so sad, consumer, you need to talk to somebody else about that? Because it's part of the sublet, as you said.
So part of the sublet is that you are getting authorization.
Right.
But the person who's going to perform.
Right, but let's assume that generates a complaint related to the tow part of the sublet. What's BAR's response going to be at that?
Oh, I mean, you're responsible for the sublet as though you did it yourself.
So I would have to have proper documentation, all the things that are part of the Automotive Repair Act surrounding that tow event, which is part of the sublet.
Well, the documentation I would imagine you would have would be some sort of receipt from the tow provider because.
Oh, no, I'm not, I'm going to do that. I'm gonna do that anyway. What I'm saying is in scenario one, where the car just, I called the tow company and the tow company says $100 and I charge the customer $100. That's not on the initial estimate invoicing. They just have a napkin that says, I towed Matt car, $100 here, Matt, you owe me $100, right? And
that's not much for
you're not going to, BR is not going to be interested in a complaint on that part of it. But BR is going to be interested in a complaint on the tow part of the sublet.
Well, in that it was in your position as the person who was contracted to perform the repairs of the motor vehicle. And so you would be responsible for what happened to the vehicle while it was on the contract.
So what I'm getting at is that's completely unclear in what this says. If this says that if I arrange a tow, I don't have to worry about it. And that's completely two separate scenarios, completely two separate answers, right? So clarity is what I'm asking for. I need to make sure that an internal tow part of the sublet that I'm arranging for, that's all processed correctly, authorized, have the documentation, so on and so forth, right? I mean, and we're going to do that anyway, right? It's silly not to, but.
This is a scenario we failed to address. I'm going to acknowledge that.
Yeah.
No, definitely. We need to take a look at it and clarify.
I feel a workshop coming on.
Can't wait. No, we're having one.
Moving
right now.
Moving on from there, and a little bit on the adopting of third party. So, most of this stuff is the body shop side of things, right? As you know, I'm the mechanical side. So, the notify the customer of third party payer estimate subject to Department of Insurance. So, typically a body shop's going to be dealing with State Farm farmers, yada, 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 right? Whereas I'm going to be dealing with a extended service or extended warranty, right? Which we're trying to get away from and call it extended service contract because it's insurance. Are those people subject to that? The assurance of the world that, that I would be using the customer bought the contract and so on and so forth. Are they subject to this?
Do either of you have questions?
Well, I mean, if I need to disclose it, I need to disclose it. As a mechanical shop, I get if it's traditional insurance, absolutely, we'll conform. But do I need to conform for the service contract?
The service contract portion of it, I don't know that they provide separate estimates where a consumer is going to arrive at your facility with an estimate from the company.
Yeah.
Whatever the company that
Well, I mean, not
they
necessarily.
advertise on TV. If they show up with an estimate and you want to adopt that estimate, it's a third party.
Oh, I got, okay, so this is inclusive to that, not separate from, okay.
Correct.
Okay, good, thank you, that's the clarity I was looking for. And correct me if I'm, misinformed here, but so as I understand a tear down estimate from the mechanical side of things, right? The transmission is kind of where this started way back when, right? So, we do all our diagnosis, properly document, yada, yada. We need to remove the transmission from the vehicle, take the transmission apart to determine what is wrong, provide you an estimate for those repairs. If you say no, thank you, your expectation as a consumer, which is well-founded, is you drove the car in, you should be able to drive it out. So my tear down estimate should be remove transmission, take transmission apart, put transmission back together with necessary seals, gaskets, and fluids, put transmission back in the car, right? Not making any repairs, right? And is that, I mean, am I accurate on that?
Oh, yeah.
Okay, good. Yeah, well, I mean, only because the body shop side of things, we're not saying that, right? The car comes in wrecked. You, as a body shop, need to supply the tear down estimate to take apart the left rear quarter panel to determine the repairs. I mean, it's wrecked. You're probably not putting it back together. But should that estimate say, oh, no, I don't want to make any repairs, I don't want to make an insurance claim, please put my bumper back on so I can drive my car away? Should it say that, right? I mean, should the body shop be saying, take it all apart, determine what's wrong, you say no, put it back together? That's the tear down estimate.
And so there's no, I won't bother. I was gonna say, you have to disclose that the disassembly of the component may.
And reassembly, though.
Will prevent the restoration.
Gotcha.
Condition
Yeah,
code up when it
okay.
was. And so
Yeah.
if you're cutting the parts off, I don't think you're putting them back on.
Yeah. Well, yeah, you hear what I'm saying, though, right? I mean, it could be a crunch bumper and you take the bumper off and all of a sudden, there's a bunch of stuff behind the bumper and the consumer says, I don't want to fix it because I don't want to put a claim in because I'm going to get dropped. So just go ahead and put my bumper back on, right? Yeah, bolted it, just bolt it back up, right?
I've seen one collision repair estimate in a complaint where the facility actually said, should you decline repairs, their language at the bottom, their disclaimers said, should you decline repairs, it'll take us 90 days to put the car back together. And we went to the facility and said, really, you're going to put it back together?
Right.
And they're like, no, probably not.
Yeah.
Then say so.
Right.
And that's what 99.9% of the collision estimates we see for a tear down is we're not putting it back.
We're not putting it back together, yeah. Whereas, in my world, a lot of times we do, right? So, and then lastly, back to the initial authorization for the tow. So, BAR's interest is basically zero, other than what it says here. But Bill, you mentioned that there's something in regulation that has 13 different steps for tow authorization.
22, when we were reviewing and looking at as part of this conversation, 22-651.07. And I want to point out that Vehicle Code Section 22-651.07 starts out, a person, including blah, 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 that charges for towing and storage. And there's always the question of, well, an ARD doesn't own a tow truck. They don't provide the towing. It's if you charge for it, you have to follow everything in the statutes. There's 2 carve-outs for ARDs, which we're not going to discuss because everybody is in agreement on what those carve-outs are for. And then, but at G, in 22-651.07 subsection G, lowercase g, itemized invoice means a written document that contains the following information, and there's 13 items enumerated there for a towing invoice.
But that's outside of BAR's purview.
That is outside of our purview. So, we don't enforce the vehicle code.
Do we mention that hey, by the way, you probably ought to go look at this and make sure you're conforming to that anywhere in right? If we don't, we should. Right, because that's completely new to me. And I've charged for tows in the past, but I've been putting on my BAR invoice, right? Yeah, not a tow invoice. So, yeah, and I'm not asking us to educate the entire world, but, oh, by the way, there are rules to play by. Go look at that. Make sure you're playing by the rules if you're charging for tows.
Well, I was going to say we were not going to talk about carve-outs, but you're not responsible as the ARD for the invoice that you're provided by a tow.
Oh, okay. So the ARDs are carved out of that section. Oh, I retract
as far as the accuracy of the information that is on the document.
Yeah, I take it all back. Thank you. That's it. Thank you very much.
Any other questions, comments from the group here? Let's ask advisory group members who are attending via the webcast or the WebEx, excuse me.
This is the moderator. We're down to just Dean, and he does not have his hand up.
Okay, we'll open it up for public comments on this presentation, and I see.
No, just to say, where you going?
Please come forward again. Yep. Welcome back. Please introduce yourself again.
Thank you for having me. Christina Cooperan, 352 Innovation. So first, I have a multi-part question, but I want to first ask so that I make sure I'm understanding this repair language correctly. So you want the shops to foreshadow like, hey, you know, this could be problem, like say your engine, right? Because I do engines and like say, okay, well, it might have got, if the head gasket let go, you know, you might have, you know, warped head and you might have, you know, this, but not go excessive, like, oh, you know, you have to replace the whole thing, but you're looking for them to foreshadow what could be found when they dig into it so that the consumer has a better idea of how much it's going to cost instead of getting it torn apart and then finding out it's $5,000 more than they were planning. Is that correct?
So I want to make sure I understand. So you're asking me that, so a consumer brings the engine in because it's knocking. What would be our expectation of a repair facility in that situation? Is that what you're asking?
Yeah, like are they supposed to forecast? Are they supposed to forecast out a little bit to help?
Oh, well, I mean, the consumer can ask how much they think in ballpark, how much it would cost. But the reality is our expectation would be that the repair facility would perform a complete diagnosis. And in this situation where you have an internal noise, we probably are going to want them to do a tear down estimate unless they're not going to. But the point is that we would hope they would do a tear down estimate in which they would be able to completely disassemble the engine and generate an itemized estimate to replace all the internal components to repair it, to restore it to operational condition.
Perfect. Then I was understanding it correctly. So my question to you guys is, when it comes to batteries, they can have a lot of hidden dangers that nobody will understand. And so when they get into these fuel cells and the batteries and stuff, the reason that they're able to go and foreshadow like what knock might end up causing problems with the engine is because they have all that experience doing so. So I'm wondering if the shops are going to have a window where they can gain that experience to understand, because like, you know, internal things with the battery is you can't take it apart, but the customer might, because like there's a thing when the batteries start to age, there's dendrite growth and those things can go off and puncture the separator and cause a big fireball. So if they go in for a collision repair and the shop doesn't catch that the battery was, you know, jeopardized, and then their car blows up 3 days later, they're going to blame the shop. And so I'm wondering, are you going to give them a window to get some of the experience and education about what are some of the failure modes of and things that they can look out for so they can warn the customer about or look for? And is there a way that they can get support to learn more of this stuff?
The window is now, and there's all whatever training provided by any automotive training institutions that want to provide that information to consumers.
To the shops.
To the shops, I'm sorry, I said consumers and I meant repair facility technicians.
Yeah, because they don't have any experience. They don't have any experience, you know, working on degraded batteries that are failing. You know, there's very little experience out there, but they all got engine experience and then fuel cells and stuff. And so I don't want to see a shop get in trouble because they just don't have the education or the experience and something's wrong with a fuel cell or a battery but those are really the biggest things. So the rest of the electronics is similar to what they've worked on before, you know, but I just don't want to see them get in trouble.
I don't want them to see them get in trouble too, unless they should be in trouble. And I would say that if a repair facility doesn't feel comfortable working on an electric vehicle, they probably shouldn't.
Thank you so much.
Thank you for coming back up to the table on this topic. Mr. Bezic, yes.
Oh. You said you weren't going to come up here.
I lied.
Well, Pete, I am thrilled that you've chosen to join me, so don't misunderstand.
Actually, what I want to do is clarify the section dealing with the when you know and when you don't know. So we can understand what I'm talking about is typically when a customer reports their claim to the insurance company, if the car is drivable, they'll ask the customer to take pictures of the vehicle and send them to the insurance company. And then the insurance company will either write an AI estimate that's based on the photographs that they've sent, or they'll send an adjuster out to look at the car at the person's place of business. In either case, those estimates, generally speaking, they're useless. But the customer gets a check. They get an estimate. Then they take the vehicle to the repair shop, and the repair shop looks at the vehicle. Now, today's vehicles, you can't just look at a vehicle from the outside and tell what the repairs are going to be. You can't even tell how to get the headlights out of the car. So you can't see the damage. So probably this is just a guess on my part, 90% of the time, the repair shop has to do a teardown. So they have one thing, they have an estimate from the insurance company and a check. They know that. That's what the insurance company has agreed that they're going to pay. They don't know what the insurance company is going to do with the estimate that the shop writes after teardown. So we have a known, we have an unknown. Where does that put the shop here when it comes to if the amount of payment to be made by the third-party payer is known?
Okay, so your question is sort of situational, dependent upon the extent of the collision damage. But we're already starting from the premise that the vehicle is drivable, and that's how they drove it to a drive-in estimating center, or, well, I guess maybe not if they took pictures and they got an estimate that was generated by AI. The point being is that I guess at the point that the consumer has this check and this estimate and they take it to the repair facility, I guess the repair shop's going to have to determine if they believe that estimate accurately reflects the repairs that are going to be necessary for the vehicle. So if it was something really minor, relatively minor, like the vehicle was just vandalized or if it's sideswiped and the estimate seems reasonable based on the amount of damage that they can see, I guess they would just adopt that estimate and include the amount that was provided by the insurance company through the check, and then proceed with the repairs. And if they find additional damage that is hidden, well, then they would do a supplement and then get additional authorization from the consumer and probably hopefully get another payment from the insurance company to perform those repairs. However, if a consumer shows up and the damage to the vehicle, well, let's just say that if the estimate that's provided by the customer is woefully inadequate and does not reflect the condition of the vehicle to the point where it's clear to the repair shop that that's not going to get it done, and then we would expect that they would generate, or we hope that we would encourage them to do a teardown estimate and then generate an itemized estimate to restore the vehicle to its pre-loss condition. That check that was provided, you are correct, is what the insurance company was willing to pay. It is not going to reflect the reality of the estimate that was generated by the repair shop at the point that they did the teardown. And so, quite frankly, I would actually expect that they would probably include both. They would probably end up including the amount that they were paid by the insurance company, and they'd have to get authorization from the customer, as they would have had to anyway. And they would probably include information on that document about the fact that the customer is going to have to go back to the insurance company to make sure that they get paid for the repair work that's necessary, or reimbursed, or that the insurance company is going to pay for the repair work. Either way.
All right, so what we've established is the fact that the fact that the shop has a copy of an estimate written by or prepared by or for the insurance, for the customer by the insurance company. That doesn't mean that the shop knows what the payment is going to be.
They know if they adopt the estimate as their own. I will also say one thing. I think in a repair situation where a repair facility determines that the estimate that was provided is woefully inadequate to the point where they're going to do something else, they probably shouldn't even accept the insurance check and give it back to the customer. Then we don't have to accommodate for that.
Well, they would accept the insurance check. They just wouldn't cash it.
Oh,
That's not the way it's done. But let's just say the repair shop is not going to repair the vehicle based on the insurance company estimate. So at that time, they can't repair the car based on the estimate provided by the insurer. So they're going to do a teardown and then give the customer a real estimate after teardown. So I will assume that because it's not really known what the insurance company is ultimately going to pay, the shop would include the disclaimer on their estimate. Am I correct with that?
Pete,
Oh, Bill's in.
look,
Second.
I moved. Fine, Bill. No, I just got here. I would say your last statement is 100% correct, that if, to Matt's point, if the repair facility determines the third-party estimate provided for the consumer is woefully inaccurate, they should prepare their own. And at that point, the amount the insurer is going to pay towards the ARD's estimate is unknown under the regulations, and then therefore it should have the disclaimer.
Okay, perfect. Then I'm going to go to your disclaimer, because the disclaimer would be on that estimate. And as Jack said, generally speaking, every estimate that we write is going to probably have that disclaimer on it. So the question is, I'm going to read this to you. This estimate is for repairs to meet the vehicle manufacturer and industry standards. As a customer, it is your responsibility to contact the third-party payer for approval of payment for the repairs you have authorized. This is important because when that customer gets that estimate, that's going to show that there's a difference of a couple of $1,000s or more than that in most cases. That customer is not authorizing anything.
You're right. They're just receiving an estimate. They would have to authorize it. They are the only one who can.
So my point is that the terminology that's in here is inaccurate. And they have not authorized anything. They're presenting an estimate to the insurance company in order to repair their vehicle as it's required to be repaired. So I have a problem. I just have a problem. Words have meanings. And the meaning of the word authorized, that customer hasn't authorized it. So that vehicle is going to be sitting in the shop until that customer authorizes it in a disassembled manner. So, well, what is your expectation from that?
I would expect that the customer authorizes the repair work. And if they don't authorize it, then nothing's going to happen until it gets authorized. You should have probably got two mics there.
Of course, we understand that the customer should authorize, and the repair shop, when they present the estimate to the customer, will ask for their authorization. But what normally happens is the customer says, wait a minute, I don't have that money. You need to talk to my insurance company, which you've done a good job here telling the customer it's their responsibility. And that's what we do in the repair industry. We tell the customer, here's what it's going to cost to repair. You have an insurance policy. You need to deal with your insurance company. And the shop, when they submit their estimate to the customer, will normally tell the customer, we need your authorization. And we're getting to the point where we're going to have to tell the customer, you're going to give us the authorization within a certain period of time, or you're going to start incurring storage and perhaps a lien.
Agreed.
That makes it simple. Okay.
Thank you, Pete. We'll look up this language. I'm looking at it, and I was just sharing with Dave maybe some fine tuning that could happen, but I think we get what you're saying. Words have meaning for sure.
Well, I understand you're writing these things for the entire auto repair industry, but there are certain things that are different between the mechanical shops and the auto body. And that's a big deal.
For sure.
Big one.
Absolutely agree.
Thank you.
We have additional comments apparently. Gene? Okay. I know I've got a bunch on the WebEx.
And hi. Matt, Bill, thanks for your presentation.
Gene Lopez? Yep.
Yeah, Gene Lopez with Sidner's Collision Centers. And so we were expecting some phone calls coming in, and I just wanted to give a brief overview of what you can expect. And it concerns me, Bill, that
I think you are not determined. This isn't going to change, I think is what you said. But I could be wrong. I think,
If I portrayed that, then that's on my bad,
okay,
because
good.
that's
So-
not, I think I even made the comment that we need to go back and take a look at this.
Okay,
And
good.
figure out what the next steps are.
Okay.
And I don't know what those are at this point.
Okay, good. So, yeah, and so there's so many different scenarios that, and Matt referred to what Pete was saying, and that was one scenario. I mean, we have vehicles, and I'm speaking about the towing portion. We have vehicles brought in over the weekend that are towed to us. And we'll get an invoice from that tow company requesting a check. And they'll come in and ask for that check. Or it might be Monday afternoon and a tow truck comes in, and before he drops off that car, he wants a check. And so there's those sort of scenarios that are going to take place that you will hear about coming up. So there is the consumer impact that we have to look at, because now they could be receiving not 2 invoices or 2 final invoices, but maybe potentially 3 or 4, depending on how many times a tow truck is moving their car. And so we have to look at the consumer impact. It's an administrative burden on our part, on the ARD's part, because now we're generating potentially 3 or 4 repair orders for that one vehicle.
And I apologize, I'm just going to point out the fact that when you talk about repair orders and invoices, those are actually defined in our laws and regulations, right? And nothing about the towing meets those requirements. So you can call it that, but it's not really an invoice or a repair order. It's a document, but I'm using that term loosely too, or we are.
Yeah, and I guess that's where the workshop's going to come in, because, because of the confusion here, we understood that a separate estimate needs to be written for a vehicle that is towed. And in our language, an estimate is a work order and or a repair order. And so for every tow, it would require an additional estimate. And Matt's shaking his head and he's saying, well, that's not defined that way. Okay, we need to define that. And so Jack referred to language that a 6th or 7th grader could understand. I think we're talking about a bunch of 5th graders in the room right now. So I'll leave it. I could go on, and there's a lot of other people that want to speak, but Chief Dore, I think this conversation should probably go into a workshop.
I'm sorry to interrupt, Pat.
I don't have any.
Forgive me here, but I had it and it's gone.
So did I. So did I.
No. All of the comments that have been made in the discussion between Jack and I, and the Bud's comments and Dave's comments, those are all, we're hearing you. And clearly we need to go back and clarify this a little more. I do want to reiterate, the 1-point matchmaking is, as of this point and as of today, as of July 1st, the requirement for whatever that document on the towing looks like does not need to meet the Automotive Repair Act. That's the 1 point we can reiterate and be firm on at this point. I think the rest of it, how we manage sublet, tows to a sublet facility and stuff like that, and what the regulations need to look like. We hear you, and we're going to definitely have to revisit all of this. And so all of the comments that everybody has made in here are very valuable to us, and we'll take those back to and try. And so for those that are waiting online, I would say the same thing. We hear you. We needed to be a little more thorough and clarify this towing section a lot more apparently than we did. And we recognize that, and we'll go back and get started doing that.
Thanks, Bill. That's important.
So thank you, Gene. Appreciate it. I've got to go to, I was trying to get to a break, but we've got apparently 9 public comments. If these are public comments that are new and different, I'm certainly interested in hearing those. But if it's a reiteration of things that have already been said, just a quick statement to that fact would be great. Because I think we've made the observation that there is more work to still be done. Moderator, could you open it up for the public comment on the WebEx?
All right, for those who don't already have their hand up, now is the time to raise your hand by tapping the hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And mobile device users, you may need to click the ellipses button, that's the ... in order to find your hand. First, we're going to call on Erica Williams. Hold on just a moment. We're sending you a request to unmute your microphone. All right, we're going to try. Erica, are you with us?
Can you, hi, can you hear me?
Yes, go ahead, please.
Oh, great. Hi, everyone. Hi, everyone.
This
This
is
is Erica Williams. You might remember me from some of the storage workshops. I work with CSAA Insurance Group as in-house counsel, and I wanted to make some comments and actually ask a lot of questions on context, which
Erica,
based on what's been.
Can I interrupt you for a
Moderator,
second?
can we jump in here and
Working
there's
on it.
2 devices apparently on at the same time, it sounds like.
Oh, let me.
Yeah, we're getting a lot of
Does this
feedback.
Does this work?
Yeah,
that is fantastic. Thank you.
Okay, yeah, I had to connect in by 2 ways in order to hear at the beginning, so it might have fixed itself. So I apologize for that. So I understand from the comments that were just had that there will be additional comment, maybe a workshop and regulations on that. So I understand that there won't be any necessary changes now, but as this is currently in effect, I'd like to kind of address on the insurance side and consumer perspective on how this will apply. So just I'll give some background on why this is concerning for us and like what CSA would like to know in treating the bills going forward. So most often towing companies will not charge the customer or the insurers for the tow. Instead, the ARD will absorb the charge and basically bill it back by including it on a final invoice after the repairs are completed or when a total loss is determined. And then the towing companies, as most should know, or at least through the this new regulation, the reference to vehicle code section 22651, there's specific towing laws that the towing companies are supposed to provide on their invoices, and the actual towing charges are supposed to be authorized by the consumer, including providing like the miles and everything that goes into the towing service. But when it's included in an ARD charge, so once the final invoice comes back after the tow is taken the vehicle to the shop, the towing invoice is more often than not withheld from the consumer and the insurer. That just goes by the wayside and is never provided. So in reference to an early comment, I don't think this new regulation is cumbersome or adding more work because that should already be done, having this invoice made by the towing provider, but it is allowing it to be more transparent to the consumer and bringing it into the BAR's jurisdiction for review to ensure the ARDs who choose to front this towing cost and bill it back, the ARDs need to make sure that they are providing disclosure of the towing services and charges to the consumer, and that the consumer actually authorized these charges to begin with, because that should be on the towing invoice. And it seems that the best method might be that simply that the ARD provides the towing invoice at the end on this separate authorization, rather separate and apart as the section E here says, from any repair work. That seems to be the clearest way. Now, there are ARDs who own towing companies, and they should already be complying with these notice provisions because they're separately licensed by their local jurisdictions to have a towing company in the first place. And so the ARDs who don't own the towing companies, though, should at least comply by their association as a towing biller to provide the towing invoice, since that's already in place under the other vehicle codes. And then there's also the world of bandit and unsolicited tows, where the tow trucks show up independently and approach the consumer or the vehicle, such as overnight when it's abandoned on the road. And regardless of the shop of choice of a consumer, the towing companies will actually take those vehicles to their ARD of choice. And so that begs the question of whether there's actually a contract for towing services between the tow company and the shop, but that's not always clear. But it doesn't matter how it gets there. Either way, in any of these scenarios, that the shop itself will typically include a single line item for the towing charge on the final invoice, and they don't provide any supporting documentation. Some do, but more often than not in our claims, we run into the issue that that's not provided, and there's no details on how the charge was calculated. So the first question I have is on this new regulation 3353E, it says if an automotive repair dealer provides or contracts for a towing service. Does this provision relate to any tow that might be included in the final bill of whether or not the ARD initiated the tow or not? Or is it only when the ARD contacts a towing provider?
It's only when the ARD either provides the tow themselves because they're a tow company or they arrange for the tow themselves. Specific to, and just go back on this, situations where the vehicle's being delivered to the shop.
Okay, so only when the ARD asks for it, such as the consumers request services from the shop.
Exactly.
Okay, thank you. And then the next question CSA has is that, is the bar going to provide a template to show how the towing invoices should be displayed from the bar, or I mean from the ARD, such as in a write it right to ensure uniformity?
No plans at the moment. I don't know where we ultimately end up on that one. Since it's not our jurisdiction, I don't know if we'd be the ones that would be providing that guidance. So there's that. You're right, though. If all the body shops wanted to just pass along the tow bill to their customers, it would meet the requirements. But I suspect that might not actually work out.
Okay, and so can you clarify if this is an absolute requirement that the collision and other ARD facilities abide by? And if they don't provide a separate invoice, what exactly is the enforcement plan?
Well, as with all new regulations, we try to educate the facility if we find a deficiency in compliance. So we'll just start there. But quite frankly, with this one, we have some additional education internally to do. So, but yeah, it's a requirement. I just don't know.
Okay,
The
and then
enforcement mechanisms can, go ahead, sorry.
Oh, sorry, I didn't mean to cut you off.
I just said, I don't know that there's
screen.
It's all right. I just don't know that there's an enforcement component to this at the moment.
Beyond the education.
I understand. So when an ARD doesn't include the invoice separately and doesn't follow this section E appropriately, should they expect to get paid for the towing charge until they do so?
I would think that if they got authorization from their consumer to pay to get the vehicle towed to their shop, they should expect to get reimbursed. Yes.
Okay, but if they don't provide that information, don't provide the written authorization or the separate invoice, they're just putting a line item on their final bill, should they expect to get paid without proof?
Well, again, they shouldn't show up on their final bill as in their final invoice, and there is no actually initial written authorization requirements other than just getting it authorized from the customer. So if they don't provide a document, I guess you probably use that term instead of invoice, but should they expect to get, well, I don't know. Great question. Guess we'll find out. I don't have an answer really at the moment. I would think that they'd expect
I would say yes.
Yeah.
Given the newness of this regulation and the lack of understanding of it, and there is some things that we still need to work out on it. Yes.
Okay, and is this supposed to be, so I guess that I understand that this needs to be thought out more and maybe explained more in future regulation additions, but if they include, say, the line item still, they don't take it off of their repair estimate, and then they also provide separate documentation. So say they do both. Is that still considered permissible, or is it an absolute where they need to remove it from their repair work?
If they're providing a separate invoice and putting it as a line item on their repair invoice, and it almost sounds like it might be charging twice for the same service, which would be something BAR would always address, has always addressed either through enforcement action. And by the way, I want to make clear our new mantra, my new mantra in the enforcement division is education is enforcement. We're required to enforce the Automotive Repair Act, compliance with the Automotive Repair Act, and sometimes education is the best method to gain that compliance. So if they do not follow the provisions of 3353E as established on July 1st, as with any regulation, the Bureau's options for enforcement from education to a formal accusation all exist. And we would take those under consideration in each transaction on a case-by-case basis. I can't commit to what it would be in any given scenario here because it would just, it's dependent upon the facts, the fact pattern at that time.
Okay, I understand the yeah, and double billing is something that we want to happen either. I ask because there is a series of software systems already in place that utilize the invoices that are submitted, and there's a question of whether that needs to change logistically. So it sounds like as long as there's no double billing and it's provided on a separate invoice, then that is more of just a nuanced issue. And the final question I have is if a carrier requests to review the signed authorization for the tow and the ARD refuses, can the consumer or third party payer refuse to pay that particular charge and still retrieve the car until it's provided?
So again, I don't know that signed authorization is required for the tow. So if you're just talking about generally, if there was some sort of documentation that doesn't meet the Automotive Repair Act requirements for how they obtain that authorization, and the repair facility and the insurance company wants to see that documentation, they wouldn't be entitled to it. So I don't know that you would be able to not pay to get the vehicle out.
Okay, the authorization I speak of is more for the towing because that is required under not the BAR universe, but in the vehicle codes that are relevant to towing. So that's it. There's an overlap, it seems, for this area where the ARDs take it on themselves to enact the tow or provide both services, as some shops do. But it seems like that needs further clarification, maybe down the road on how that can be handled because sometimes that's the only dispute at issue before the car is retrieved after repair or tear down. And that's been coming up more and more.
Okay, thank you.
Yeah, thank you so much. And if the BAR does do a towing / tear down workshop, it would be nice to include some additional provisions regarding the towing aspect when they don't contract with it and instead try to bill back, which is probably a more common instance. Thank you very much for your time.
All right. Thank you very much. Moderator, before I take any more public comments, we are going to take a long overdue break that is on the agenda for 15 minutes, and we'll come back to the public comments that are remaining on the WebEx. Let's say 12:04, we'll come back. That's 15 minutes. It sounds like we're being recorded again. So we will resume our meeting and our discussion on the topic involving the ARD or Automotive Repair Dealer tear down and disclosure requirements. That's the regulations that took effect on July 1 of this year. Moderator, can we continue with the public comments that
Yes, indeed.
are scheduled or lined up for this topic?
We still have several hands up, and next we have Elisa. Correct me if I pronounce that incorrectly. We're sending you a request to unmute your microphone.
Okay, I believe I'm unmuted.
Yes, indeed.
Okay, so first up, in regards to the towing, I'm a tad bit confused. Since there's absolutely no other reason for a tow to go to an auto repair dealer besides obtaining an estimate for repair, how is that not a sublet for repairs? How's that not part of the process? Because it's not separate. They're not towing into me for any other reason but to obtain an estimate for repair.
I'll answer this, but we did cover this, that the act of transporting a vehicle is automotive repair related, but it is itself not automotive repair. So it is not actually a sublet. But anyway, did you have any other comments?
Yeah, I do. And I just want to clarify on third-party payments, the software that we use within CCC, it actually, there's a whole section where I can say where the insurance company gave them a check, they dropped off the check. The check was, say, $1,500 on a $3,500 payment, but we hold that as basically a deposit on their account. Is that correct?
I've heard differing information. I don't really know if I'm going to be able to give you advice on whether you should keep an insurance check for an estimate you don't intend to perform. So
Oh,
I
no,
don't know that I have an answer.
we intend to perform them, but the issue is these AI estimates that are coming out, they are 90, literally, I've never had one that was correct, that didn't require 15 estimates because they get a supplement back, they hit the AI button again, they send it back, they miss a bunch of things we put on there. It looks nothing like the estimate should be, and it's actually causing a massive backup. So we've been approved to do the estimate that we've done because you guys assume a lot of time that the insurance company does the initial estimate, and that's not our experience. So, and we don't go off of what they say anyways, because they love to leave out processes and charges and all kinds of stuff. But what we do is we get authorized on the estimate that we will be performing to the vehicle as authorized by the customer and the consumer. And then when the insurance company will send them a check on the initial, because it just happens automatically by computer. So that's just what happens. So we can receive that check and put that check within their account because it states it on every document they get. It prints that out and they receive it. So is that appropriate or not?
Good afternoon, Elisa, sorry. Nice to
Okay.
talk to you again. I think we got a little off track on that. As far as the checks, those don't constitute an agreement by the insurance company to pay a specific amount. They're based upon an initial estimate that was probably inaccurate, as stated numerous times throughout this workshop. So it goes back to the question, it's the reg section we're talking about is what should be noted on the estimate from the ARD to the consumer after the ARD has done a tear down or a thorough inspection. And there's two qualifiers there. If the amount the insurer is going to pay is known, the ARD shall do A. And if the amount is unknown, the ARD shall do B, which is include the disclaimer, or not, it's not a disclaimer, the statement on the estimate that informs the consumer that's to repair the vehicle properly and they need to get authorization for payment from the third-party payer. The check is not considered in that equation. And if you're not accepting the insurance company's estimate, the AI estimate, as you called it, then your estimate, the amount the insurer is going to pay, that's a new estimate, the amount the insurer is going to pay towards that is unknown. You don't know what they're going to pay. So it falls under the second half of that regulation.
Okay. Well, we kind of inform the owner of the vehicle that We have no contract with any insurance company, and we do it as a service to them. And we include them in all of our emails going back and forth with the insurance company, so they're completely aware of everything that's happening. So we also have the disclaimers in, and we do all these things. I just want to make sure I'm straight with this.
Yeah. Yes, you're straight then. All right, there we go.
Okay. That's what I needed.
Okay.
And then another thing with Erica from CSAA, we provide all the documentation to the consumer. I have no requirements anywhere to provide them any invoices at all whatsoever, according to DOI regs. So if they request that they need a copy of said tow bill, then the customer does receive copies of all of those things from my shop. And if she requires those from the customer, she's more than happy to request them.
Yeah, I think that's part of the issue that's going to be addressed later as we
Okay.
review the towing portion of this.
And then another thing, one last, Matthew, hello, it's Lisa. So when we had a discussion before at a meeting, you told me that we were supposed to itemize down to the last razor blade and the last penny on authorizations, which we do.
And Elisa,
Yeah.
you're the one who got me the brownie, right?
I did.
Look at you. No, you don't have to obviously itemize to a razor blade, but you do have to itemize parts. I mean, it is in that shop supplies would just be rolled into whatever you're.
Okay,
shop
so the
hours, right?
issue that's occurring now is it's causing a rift, and maybe we need to discuss this outside of the towing and everything else. So I'll send you an email. Patrick is apprised. Maybe you need to be in on that, and Bill, of what's actually occurring in regards to itemizing lists and itemizing things that we're doing to the vehicle. And
We're very well aware of this, of what you're doing, and other ARDs are starting to do. And it's an interesting approach. You and I had that conversation last week about that.
Mhm.
And then I know that CDI sent Johnny an email this morning
Yes.
with their position on it. So I think, and I don't mean to cut you off. I certainly apologize.
Oh, no,
for
I
how we
understand. That's something we can discuss further later.
That's a whole entire different topic that definitely needs to be looked into and have some conversations about, is the
Perfect.
itemized billing for
I'm here
supplies.
for it. You guys go ahead and
Yep.
continue on. Thank you for hearing all of us.
You're welcome.
Thank you, Lisa. Moderator, next commenter.
Next, we have Mel, Craftsman Collision. Hold on just a moment. We're sending you a request to unmute your microphone.
Oh, yeah. Yeah.
All right, Mel, we're going to try again. We're sending you a second request to unmute your microphone. You should have a prompt in the middle of your screen saying unmute me. And if you're on a mobile device, then you may need to go down to the ... in order to.
How about now?
Welcome.
Hey, okay. Hi guys. Hi Matt.
Hello.
I, like everybody else, sorry we're beating a dead horse, but I want to really understand this about the separate towing. If I give you a scenario, can you tell me if this is 1, 2, or 3 invoices? So, and this, because this happens all the time. I get a Ram truck towed in that was a stolen recovery. So I have the initial tow bill to get it into my shop because the windows have been smashed and the guy doesn't want to keep it on the street for too long, which is fair. It comes in and the ignition is all punched out. So, and it's not something my mechanic can do because there's all this electrical. So now I'm going to tow it to the dealership. So it's come into my shop. I've written my estimate. He's cool with that. But now I got to tow it to the dealership because now it's got this no start issue. So now we're a second tow over to the dealership, and then they're going to get it running. So we drive it back. So that's easy. But now I'm kind of like not figuring out what's included in my estimate, my repair estimate, and what's not. Is it 3 separate invoices for this one job? Because it's the first tow bill that came in, then it's my repair estimate. Then I have to separately charge for the tow to the dealer.
Yeah, so there's only one invoice, which is going to be the invoice that you generate for the repairs. What we're
Right.
actually talking about is how many documents do you have to give the customer related to the tows?
Right.
And I saw your email where you laid this scenario out. And I had hoped that when you had listened to our presentation, this is one in the email, right?
Yeah, pretty much, but I've added an extra tow just for kicks.
Oh, okay.
Because it happened.
But look,
You know, like,
the reason
lots
I
of-
didn't,
lots of these situations happen, you know,
knowing that we
electric
were,
cars have to be towed
sorry.
back and forth to the dealer twice, you know, once to de-energize them, and then it comes back, and then it goes back to be re-energized. So, you know, we have lots of scenarios where there's multiple tows within the repair. So
And
can
the
this,
reason-
yeah, go
well,
on, sorry.
I was going to say is that I knew we were going to do the presentation. I figured you'd watch it, and then I would have answered your question without you having to ask, and I would have been the genius who handled it all at one time. Having said that, the expectation would be that you get authorization for the initial tow. Again, that authorization doesn't have to meet the requirements of the Automotive Repair Act. So however you get a thumbs up from that customer to get the vehicle towed to your shop, it's all good. There would be some sort of document theoretically you would provide related to that tow. What form that document would take, it's not a requirement of the Automotive Repair Act.
Sure.
So there you go. And what we were talking about related to sublet is that the sublet is just the means of transportation of the vehicle to the facility that's going to perform the repairs that you are not going to perform. So you're subletting the vehicle to that shop. And it really is just part of the sublet process itself and would be included in that price. And therefore, we are saying we don't think that another document would be necessary. So there would only be whatever you have related to the initial tow and then the invoice for the repairs.
Okay.
And that's where we left it.
Okay, cool. So is that 2 invoices? So the $200 to get it to my shop and then the repair?
And I'm not trying to be like playing, what is it, pedantic. I'm not trying to be pedantic about the description of the documents in that an invoice is defined by regulations and by our laws and regulations. Like you're not giving them an invoice related to the tow, but you're giving them some document related to the tow. And so therefore, when you say invoice from our perspective, I'm listening to you tell me that it's a document that's going to contain, right, your ARD number, your business name, your address, you know, it's going to list all the parts and all the service work performed and all the, you know, so the point is that I'm not asking you to give them that for the tow, but there is some sort of document that you would provide to them that could be much simpler than that about the $200 for the tow.
Okay, so I mean, then it sounds like it is just a line item like we've always been doing it, but the line
Just the
item might
lines on it.
include something
The lines
about
on it.
customer authorized us to tow the vehicle in for inspection and repair.
You can make it as complicated, I guess, as you want, and that sounds good to us. I just don't know that you need that much.
But it's one work order. So even though we have to, you know, we're itemizing this stuff anyway, but you're saying it's one invoice, one work order.
Okay, I can go with that, I guess. Unless, Bill, you have something you want to say about that?
There should be a work order, an estimate work order, and invoice for the repair transaction. And then there should be a document of some sort for the towing charges. So there would be 2 for the initial tow, not the towing for the sublet.
Okay.
So 2 documents. One is an invoice per the Automotive Repair Act. The other is something that charges for towing.
Okay, so if it's that initial tow, we are talking about 2 you know, like for those of us that use CCC or whatever, we're calling them ROs, we're calling them repair orders, we're calling them invoices. So you're saying if it's an initial tow in, that's a separate deal, a separate invoice. Then the repair, no matter how many tows, you can tow it all over town, who cares? Well, you know what I mean.
Right.
But that would
No,
just
right.
be all sublet within that one repair.
That's a part of the cost of subletting the vehicle.
Got it. Okay, so we are adding one level of complexity, but we're not adding every single one. So if it's an outside tow to bring it in, okay, that's what it's supposed to be, which is kind of crazy. I mean, I understand where you guys are getting this from, but whoever's making these decisions has not worked in a shop or worked with insurance companies, because it's not going to be great to deal with it this way. And I guess that was what my email, Matt, was about, was, you know, when the insurance company is going to pay for the repair and they're going to be like, great, it was $3,500, that's the repair. And it's like, oh yeah, but there's also this $200 thing. It was really supposed to be $3,700, but now I'm sending you something for $35 and something separate for $200. So that's a drag, dudes. Just saying. I did have a second thing, and Matt, I sent you a second email on this too. Is Write It Right used to be in a nice PDF where I could print it off and keep one in the office and then point to it when my guys say, I don't want to do all this. And I say, yes, you do. You have to do it. Where did the PDF go? Does that still exist?
I don't believe it does. It's a question. I understand it was converted to an HTML format to give us the ability to change it on the fly after conversations like today's. So I believe there's a link or an ability to print it on our website, and I will have Matt, since he has your email address and you've emailed him, I am just asking Matt, directing. He's being voluntold to provide you with a link to the place to print that.
All right. Yeah, I mean, if you print the website, it is ugly. It is very ugly. Whereas, you know, the booklet, we actually did keep one here, and I'm not trying to be a brown noser, but you guys, you know, it actually just helps me as a teaching tool because I've got 4 estimators here, and when they say, oh, well, why do I have to do this? I'm just like, well, here's why, and here's how you word it. You know, it's a good reference when I need it. So if there's anything you guys can do about a printable format that's not super ugly would be very much appreciated.
Done. Well, I'll see what I get to you on Monday.
Thank you guys. I appreciate it.
Thank you.
Thanks, Mom.
Excellent. Yeah.
Next, we have Hilal Shamam. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hi, can you guys hear me?
Yes, go ahead, please.
Great. All right. So I appreciate you having me. I want to make sure I understand a particular scenario. So based on what everyone's saying right now and hearing more about it, it sounds like you want a sort of a transaction that shows a towing accomplishment, however you want to call it, sublet or whatever. So if I can prove that a customer authorized that, right, that would be acceptable. So for example, I have a customer who had their car on the street overnight, someone slammed into it. So she calls me and says, hey, I need an estimate. And so I say, well, can you send me some photos? And she says, you know, I'm really bad with technology. I just want to tow it over to you. So I send her a document that says, I'm going to tow your car over to my shop for $250 based on where you say you're at and provide you a free estimate based on a visual inspection. And so that's one line. And then the next line is, I'm going to provide you a free estimate based on a visual inspection for $0. And then I'm going to have a disclaimer. My storage charge is $200 a day. And if I disassemble this vehicle, I won't reassemble it for various reasons. And I would be more specific than that. So is that invoice acceptable to you?
I would think not, because you're describing putting the towing on the first line of the invoice. Again, once that consumer calls you and asks to get the vehicle off the side of the road to your facility to prepare an estimate, whatever that cost for that estimate process is, and you tell her, in your example, it's $250, you don't have to send her a document. You don't have to gain. You've secured authorization for the towing at that point.
How did I do that without a signed document? You guys need a wet signature.
No, not on towing. Towing is not regulated by the Bureau of Automotive Repair, and it's not subject to any of the requirements of the Automotive Repair Act requiring estimate, authorization, documentation, and an invoice.
Well, maybe that's for you, but in a court of law, you'd like to see a signed document.
I'm telling you what the Business and Professions Code says and what the regulations say. You do not have to have a signed document for
Okay, but
towing.
it is better to have one, is it not?
whatever your choice is to run your
No,
business.
no. Look, you're here to actually help us succeed, right? We're trying to actually do a service for the consumer here. I'm giving them a document to go ahead and sign for something for it so that they have all this information before they enter into a contract with me. You're basically saying to give a
You're
post.
certainly free to do that, but I'm not going to look at that document and I don't regulate that document.
So then I still don't understand why my document that I just gave isn't sufficient.
Because the vehicle code says that towing shall be authorized on a separate document from the document that where repairs are authorized.
So you want me just to have a document that says I'm towing your vehicle to my shop for $250 for no apparent reason? Because that's what you're
Yes.
saying I'm doing. I'm basically towing it off the street and just leaving it at my shop. Well, I feel like that's absurd and that needs to be changed. I don't agree with that. I don't know where it says that in the Repair Act. I'd love to see that. I'm not, obviously not educated, but that makes no sense.
It
And
doesn't
to
say it in
actually
the
try and
Automotive Repair Act.
overregulate us, we already work a lot of hours. You're making it more difficult.
It
I
doesn't
think
say
that
it in the
before you
Automotive
guys made
Repair
this
Act.
code and made this happen, you guys should have talked to us a little bit more before you went ahead and implemented something that's going to make things a lot harder for us. And I don't appreciate that you guys laugh about it and make this seem like this is not a big deal. This is a major big deal. For me to actually create more transactions in my management system makes a lot more work. And then I got to charge consumers more because my time is not for free.
Thank you.
Thank you for your comments. We appreciate them and we'll take them under
Yeah, of
advisement in
course.
future versions.
Yeah, whatever.
Next comment.
Next, we have Jerry Forhealth. Hold on just a moment, please. We're sending you a request to unmute your microphone. All right, Jerry, we're going to try again. We're sending you a second request to unmute your microphone. If you're on a mobile device, you may need to hit the ... in order to find that unmute. All right, Jerry, we're going to circle back to you in just a moment. Next, we're going to hear from MW. Hold on, MW. We're sending you a request to unmute your microphone.
Can you hear me okay?
Yes, go ahead, please.
Okay, as Mel said, to beat a dead horse, just to be crystal clear, insurance company tows the car to the shop, body shop. That tow dollar amount cannot be anywhere on that estimate of repair, period.
And I just want to clarify, that's your question, right? As opposed to a statement?
That's the first part. Yeah, the first part of it. Yeah.
And so we are saying yes to that.
Yes, it can be, or it cannot, or it should
Yes,
not be.
Yes, it can be. It can't be. It cannot be it's not supposed to be on your repair estimate. It's a separate document.
Okay, so I think that's the frustration here. I understand the document part of it. My document for the tow bill is the invoice. It doesn't need a repair order, doesn't need authorization, date, timestamp. So that's the easy part. I think that's the confusion everybody's worried about. We have to have all this repair orders and signatures. So that's the easy part of this. But now I have to figure out a way to get paid from the insurance company because it can be nowhere on my estimate. If I move cars internally, from say shop to shop, it's not a sublet. That's going to be a similar instance. I just have to say, here's a copy of the tow bill, even though nobody's having to pay for it. I still have to provide that tow bill. So I have a car that's at shop A. I'm going to move it internally to my own shop B. There's no cost to an insurance, or there's no cost associated to the customer. I get their authorization to move it. I still need to give them a copy of that tow bill regardless at the end of the repair. You guys care about that, right?
You say you're doing it because you do it? Or are you asking us if We say you
Yeah, no,
need to.
we do it for, yeah, so I have to take it to a certified shop, for example. This shop isn't certified in, let's say, BMW. So I move it internally within my own company and it gets towed out. So I'm just telling the customer, hey, I'm towing it to a certified shop. There's no charges incurred, but I still have to do that and provide that invoice regardless, right?
No, but if you want to, you can.
Okay, okay. All right, so that's just a phone call similar to what we do now. So that was really my only question, just again to clarify. I don't need a second repair order, no authorizations, date, timestamp. The actual tow bill will act as that document. That's the easy part. And do not put any tow bills on any repair estimates unless it's associated with a sublet transaction.
Even if it's associated with a sublet transaction.
No.
The sublet,
No.
no, the sublet has to be, but not the tow related to the sublet.
You guys just talked about moving. If I had to tow it to a
I think we
dealer
said
or
that.
whatever, that's a part of my repair estimate.
Yeah, if you are going to, so if you're subletting work to another shop, obviously you have to get authorization for the sublet, and the transporting of that vehicle is part of that sublet.
Yes.
And we're not saying that, so, but if you're asking me if you have to report on that invoice or get authorization for that tow for that sublet, the answer we're saying is no.
Yeah, I got that part. But I can add that tow to my estimate, just not that original one.
Yeah.
Got it.
Okay.
Okay. Clear as mud. Thank you guys very much.
Thank you.
All right, next we're going to hear from Jerry Forhilf. We're going to try that again.
Good afternoon.
Good afternoon. Go ahead, please.
This is Jerry Froelich, JBS Consulting. Thank you, Pat. Thank you, Matt, for your presentation and Bill for your input. Being ex-bureau, I have one little thing for clarity and then two issues, or kind of like two issues that I wanted to present to you from a manufacturer and dealership point. The first part of the question is, you receive a complaint. The complaint talks about repairs not performed as estimated, and then also that they complain that their tow document, they were never told how much the towing was going to be charged, and the tow document from the ARD facility does not show an amount. Does that tow document then become under your purview?
Again, towing is not, it's associated to automotive repair, but it's not automotive repair, which is what we regulate. So are we going to look into it and try and assist the consumer in working with the facility to resolve the situation? Jerry, you know the answer to the question. Yes, we're always going to do that.
Okay, and I'm just getting at, because it's under 3353 in the past, shall we say. Now this, I know from today's comments and so forth, this is different, but in the past it would become under the bar's purview. Okay, the second part, just so you know, a lot of manufacturers will have their dealerships tow in a customer's car, which requires the ARD to contract for the towing. So the ARD then has to use their repair order system as a quote unquote tow document. The manufacturer will not pay for that towing that the dealership had to contract from an outside source unless it shows up on their quote unquote repair document. So there's going to have to be, to satisfy the manufacturer on the repair order for repairing the car, a line item that says something along the line, towing provided by the manufacturer, and then on the invoice they can charge out the PO and the manufacturer's code number. This also works with concierge service, because there's also manufacturers that have them do concierge service via outside towing. The reason, one of the concerns with this is now they have two documents. Manufacturers do what they call an RO count. And what they're looking for is repair orders that do not have automotive repair on. The towing documents, I have talked to a manufacturer rep on this, will be looked as a negative aspect of the dealership, and that could cause negative accents to them being with parts and labor charges under warranty. Just wanted you guys to be aware of that.
We'll take that into consideration in future steps.
Thank
Much
you.
appreciated, Jerry. Thank you.
Bill, excuse me, Bill, just real quick. If you guys don't care about this, who would? Right? I mean, if the shop has to do all this extra work and you guys don't even care about the repair aspect of it, who would care about it? And why are we doing all this extra work for people that don't care about it?
Thank you for your comment, Bud.
Moderator, any other questions, comments, any other public comment?
Yes, indeed. We still have a line. Next, we're going to hear from Keith. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Can you hear me now?
Yes, go ahead, please.
Perfect. So my question is about the third party payment disclosure. So we get the vehicle in, we do a tear down authorization, we write a complete estimate, we send it to the customer for their approval and the insurance company for their approval. The insurance company kicks it back and deems they found aftermarket parts, used, salvage, in accordance to the customer's policy. Now, we have to put that statement that says this, and then we go to the customer and go, okay, your insurance company wants to use aftermarket parts. We're writing for OEM. Do you want to pay the difference? If the customer says no, do we still have to leave that statement saying that this estimate's written in accordance to manufacturer and industry standards? If that makes sense to you guys.
It does. And thank you for the question other than tow. Yes. The purpose of that statement at the bottom is to inform the disclosure, as we're calling it, when you don't know the amount the insurer is going to pay, in the statement that you are going to repair the vehicle to manufacturer and industry standards, and it's their responsibility to get authorization for payment of the amount they authorize or maybe going to authorize once they check with their insurance company. When that insurance company replies, the Fair Claim Settlement Practices regulation requires them to send that notification that they are going to require the use of aftermarket parts and other adjustments to your estimate. That has to go to both you and the consumer. And that's the primary purpose of that disclosure, is to initiate that conversation between you and the consumer. After, if you adjust your estimate or whatever the negotiations, the conversations that take place between the insurer, yourself, the repair facility, and the consumer, and whatever changes are made to the estimate, once there's a final estimate, that disclosure wouldn't be required there, because that's not the estimate after teardown. It's only on the estimate after initial teardown and diagnosis. Hopefully my answer kind of clarified that. Yeah.
So if we adjusted our initial estimate, only adjusting the parts, like going, okay, we're going to aftermarket fender, recondition wheel, or whatever the insurance company put on it as per their policy, we can remove that statement.
That wouldn't be on any follow-up estimates, because those are now renegotiated estimates, if you will. It's only on the initial one that you provide to the customer after teardown.
Okay, completely understand. Perfect.
Okay.
All right. We potentially have two more. Next is Angel Cordero. Hold on just a moment, please. We're going to send you a request to unmute your microphone.
Gentlemen.
I think we heard you, Angel. Try again, please.
Excellent. Excellent. I'm calling on a little bit of a different subject than tow, so we can avoid that. I'm not sure if the board is aware that there was a Senate Bill 88. It was signed back in October of 2023, and it was just implemented as of July 1st of 2025. Now, the reason why I bring this up is that there's only one portion that applies to the Board of Automotive Repair, and I'll be specific as to what section it is. It's SB 88 is the Senate bill, section 39879, letter C, number 1. This is some help I need in clarifying this. And it says, I'll read it verbatim. It says, any vehicle used to provide pupil transportation for compensation by a local education agency shall meet both of the following. Here's the part where it applies to BAR. The vehicle must be inspected every 12 months or 50,000 miles, whichever comes first, at a facility licensed by the Bureau of Automotive Repair to ensure that the vehicle passes a 19-point vehicle inspection as adopted by the Public Utilities Commission. And it goes a little bit farther. Now, the reason what I'm asking is that currently I work for a transportation company here in Southern California, and the safety and compliance officer company. And we currently, the current standard for California is we have 3,000 miles or 45 days. The vehicle is inspected by our and trained mechanics, and we fill out forms and we keep them record for when we have our inspections by the CHP. Now, this new law, are we now having to take our vehicles to an actual certified location to get these vehicles inspected, or do we still continue using the 40-point inspection required by CHP?
I don't know how to answer that question other than it's not under the Bureau of Automotive Repair. That is not an inspection. This sounds like the 19-point inspection, as I recall, is for, well, I thought it was rideshare programs in particular to keep those vehicles in compliance with the program requirements. Who regulates that? It was, I want to say, CPUC, yeah, Public Utilities Commission. So the only requirement that we are aware of, and I'm not sure about the 19 versus the 40-point inspection, that would be the agency I would check with. The only requirement that we're aware of with this new law is that it has to be done at a licensed automotive repair facility, licensed by the Bureau of Automotive Repair. As far as the type of inspection, that is not something we have any hand in or knowledge of. Is he still there?
This is the moderator. We muted his mic because there was an echo.
Okay.
Angel, we've sent you a request to unmute your mic again.
Yeah, we'll try to get some information to you.
Let me go ahead and lower my speaker here. So the reason why I'm asking is we were unsure on whether the CHP inspection supersedes this inspection done by a certified Bureau of Automotive Repair location.
Yeah, that's a question I don't think the Bureau of Automotive Repair is going to be able to answer. That's not something that falls under our jurisdiction at all.
I see. Okay, we're just, like I said, we're just trying to be compliant and just understand whether or not, who do we take our vehicles to if we have to? And another question, just in the same sort of area, is can we as a company, because we have several vehicles and we do work for several school districts, transporting students both on elementary, high school, and even college level of extracurricular activities. We have school and sports. What I want to know was if we can create our own, in other words, get our own certification for our own business here. And then does that cover us?
Yeah, I don't know that the CPUC would, again, as Pat mentioned, the CPUC would be the ones to check with on that.
Okay.
I don't know if they're going to allow you to secure an ARD. An ARD is required of anybody that performs repairs to automobiles for compensation in the state. So I don't know if you would, I don't know if you would fall under that definition, but I think ultimately that would be CPUC's determination.
Okay, I will follow up with them. I appreciate your time.
Yep. Thank you.
Thank you.
That was outside
Next.
the scope of the presentation, but it was a public comment that would have come up in the later part of our agenda.
Next and potentially last, we're going to hear from Hilal Shamam. Hold on just a moment, please.
We heard from him.
Hi, thank you. So I guess the here is that we're talking about collision damage repair here, right? And so in collision damage repair, there's upholstery repair, right? That happens in repair. There's mechanical repair, there's auto body repair, and there's paint repair. And then lastly, there's towing repair. Towing is part of the repair. And it's unclear to me on why you guys are trying to separate it. And I'd like to know what that agenda is. There seems to be some sort of hidden agenda to separate it as part of the repair. Towing a car to a facility is part of the repair. Why? What is the advantage of you guys making it harder and over-regulating us to try and separate it with a transaction? I mean, you guys are here to actually do a benefit for the consumer. We are giving it my example before gave a perfect example of how to give the customer an opportunity to know what they were paying for. And you're telling me I can't do that. I have a serious problem with that. And I'd like to know what your agenda is.
The agenda was to comply with the vehicle code and make sure that we had our automotive repair dealers licensed by the Bureau of Automotive Repair.
Yeah, towing is part of the repair. I have news. It's
and
part of the
the
repair.
point's been,
part of the Repair Act. I'm not a lawyer, and I don't think you are either. I feel like you are trying to put something here on us for no reason. There's no advantage to any of this for you to separate. And I'd like you to tell us what the advantage of separating a towing repair, which is part of the collision damage repair. That is what we do.
The point has been made, and I appreciate the comment. There was no hidden agenda.
You're not answering the question.
I'm trying to get to the
questions.
What
What is the answer of why towing repair is not part of collision damage repair? I still have not heard the answer to that.
The answer is that we were trying to separate and make much easier on automotive repair dealers the process for collecting for.
Well, who did you ask to do that? Did you go around shops that asked that before you guys put it as a regulation? I mean, someone should be for this. Someone should. I would like to know who hired these people to actually do that.
I don't have a response to the question. What was I don't even know what the question was. That
My
last
question
one
is I don't understand. You still have not explained to me and made it clear, crystal clear on why towing repair is not part of collision damage repair and why you guys are separating it. The only answer I'm getting out of that is, well, we're trying to figure it out. Well, you should have tried to figure it out and talk to body shops before you guys made it a regulation.
Let me,
I'll just answer one question. You keep calling it a towing repair. We're not calling it a part of the repair. The initial tow into the shop is not part of the repair transaction. That's all we've done here.
Where does it say that? Where does it specifically say that?
It said that in the vehicle code section that we pointed out earlier
Can you
in the
read it out to
discussion.
me? Because you should have that memorized, because that's a critical part.
We do
Please
have
read
it.
that to me. Please read that to me.
Please,
Where it
with
says
some
towing repair.
professionalism
Hold
and
on,
respect,
hold on,
please,
and wait.
sir.
And here's what's funny is that, so you're saying it is part of a sublet repair, but it's not part of the body collision repair. Do you see how that gets confusing? If I have to tow a car to get it to the shop to figure out what's been damaged, that's part of the repair.
Okay,
But
so
it
let
is
me,
included
I'm going to answer
when
your
I
question.
sublet it to
If you
take the
allow me
loan
to.
out, or to get suspension out, or to get recalibration done, but it's not included in that. And yet you guys want to over-regulate and give us more things to do, and you're not even telling us what the advantage is.
So automotive repair is defined in the Business and Professions Code section 9880.1K, and it defines automotive repair as the diagnosis of malfunction. And well, automotive repair is the diagnosis of the malfunctions of motor vehicles. And so a tow itself is not considered automotive repair. Therefore,
According to who?
it doesn't.
Where does it
According
say
to
that?
the definition of automotive repair, it
Does it
is
say
not
towing?
automotive
Does it
repair.
say
It is the
towing repair is
transportation of a
not
motor
part of it?
vehicle.
No, it's not. It's you're towing a car to get an estimate and fix the car. It's part of it. I'm not going to put it on my back. I have to get it to the shop to actually figure out how to repair it. So this is semantics, dude. I don't understand where you get this from. You are making
So,
this up. Are you a
Vehicle
lawyer?
Code Section
Where are you coming up with
2261,
this? For the past 100 years, for the
2265.1.07
past 50 years.
says
no,
that
it
the
doesn't say-
authorization for the tow has to be recorded on a separate document from the repair estimate.
I'm sorry. Can you say that again? I want to hear that again.
I will point out that I've said it a couple times during our presentation.
I know
and
you
will
have.
Say it
I'd
again
like
for
to-
you.
I'm
It is
gonna write it down.
2265.1.07.
Okay. So what did you guys, for the past 50 years, towing estimates have been on the estimate for collision repair. What did you guys decide to do, change that this year? What has made you decide for the past 75 years that the Department of Consumer Affairs, and I'm assuming that, right? But for a long time, we've been doing it a certain way. What gives you guys the authority to go and change that and make it difficult for not only the body shops, but for the consumers to understand what we're doing? What is your point? What are you trying to accomplish?
So I think the question you asked me is why we're doing this now as opposed to why didn't we do this in 2010 when 2265.1.07 became the law? The answer is we didn't know that the law had changed to say that you had to separate out these two authorizations for the tow and for the repair. The reason we know it now is because we've been doing a lot of work on storage fees. And as a result of that work, we came across this wording. And in order to ensure that things are being done in accordance with not only the Automotive Repair Act, but the Vehicle Code, we have introduced it in our regulations. Now, we did a workshop on this regulation back in October of 2023. We had a 45-day comment period in February and March, I think, of this year. No, I think it was actually November and December of 2024. And then we had an additional 15-day comment period in February and March of this year. And I will also say that that provision was in our storage regs up until the 15-day comment period for this regulations. And we did 4 workshops on that regulation. So we have been putting out to the industry to try to give them information about what we're seeing and why we're seeing it and trying to get feedback. And now we're getting it. But the regulations have become effective at this point.
Right. So I think it was, if you weren't getting feedback, obviously we weren't hearing about it. You shouldn't have put it on the regulation yet. You should have done a better job of getting feedback from shops, because no shop that I know of, right? And by the way, I'd like to know what what you guys did to get information from the shops to really get feedback, because obviously you're getting the feedback now. What did you really do? You're saying you went out and you had these, I guess workshops or whatever you just said, but how much feedback did you get back? It doesn't sound like you got anything.
We got an immense amount of feedback on our storage regulations repeatedly. And I know because I was there and I had to do it.
Bits.
But not on this
We're
issue.
talking about separating towing repair. I'm talking about separating towing repair. What
It was in the
feedback did you
regulations.
get
That's
that
the
was
point I'm making.
positive? But what was the positive feedback that you got about separating towing repair from a repair bill? How does that, it doesn't make any sense, and try to explain to me that, well, towing repair is not part of the repair. I'm sorry, dude, that is total BS. It is total BS. Towing is part of the repair. And I could argue with you that all day long, and no one has the time for it. But you had no business going and changing that regulation without really having a better understanding of what kind of a negative react, not just for the body shops, but for the consumers. You have made it worse for the consumers, and your organization was made to protect the consumer. So you guys should be ashamed of what you guys did.
I appreciate your comment.
Thank you.
Yeah, I don't think so. I don't think you are. You do approve it. Appreciate it.
All right. Moderator, do we have another public commenter?
We saw a hand pop up and then down. We're going to give just a second for that hand to come back up before we move on. All right, I think, oh, hold on. Ralph Wood, hold on just a moment. We're sending you a request to unmute your microphone. You are potentially the last commenter. All right, Ralph, we're going to send you another request to unmute your microphone. If you're on a desktop computer, you should see Unmute Me in the middle of the screen. If you're on a mobile device, you may need to hit the ... in order to find the Unmute Me.
Can you hear me now?
Yes, go ahead, please.
Thank you for having me. So just for clarity, as of right now, unless I know you're going to have a workshop, the original tow bill, regardless of who pays for it, needs to be on a separate invoice. Any sublet related repairs for calibrations, alignment, mechanical, etc., that can be on the original on our repair order, correct?
That's correct.
That's all I needed. Thank you.
Thank you, Ralph. That
We are
sounds
finished.
like our last commenter.
Yes, indeed.
All right. We will close this agenda item. Thank you very much. More discussion to come.
We're going to change the fifth graders, so no more pedantic words.
That was pretty good.
Yeah, I got
All right. We are closing in on the 1 o'clock hour. Our agenda gives us coverage for this, so I apologize. We are going to run over. We did not anticipate the length of time needed for this last agenda item, but we will go on as our agenda allows with the statement or until close of business, and our business has not yet closed. So our next presenter. Well, don't worry. We'll not do to you what we did to Matt and Bill, but I'm certain of that. Oh, I'm certain of that. We're going to have a presentation on our California Vehicle Inspection System. It's an update that we do every couple of meetings to give you the latest things coming down the pipeline for the CalViz system. Here to give that presentation is Paul Hedgeland with our Engineering and Research Branch at the Bureau of Automotive Repair. Welcome, Paul. Thank you for sitting so patiently throughout the day to get to this point.
Sure. Keep it brief. Thank you. An update on CalViz. That's our California Vehicle Inspection System. We try and do these updates every 6 months, more or less, just to keep you updated with what we've been working on. Quick overview to start. The California Vehicle Inspection System, otherwise known as CalViz, it's the information technology solution that supports smog check and recently vehicle safety systems inspections. It's comprised of all sorts of technology, data centers, hardware, software, network connectivity. A lot of effort goes into maintenance and operations behind the scenes that we don't see as end users. Continuous monitoring, patching, functional updates, accommodate new business, all necessary to achieve availability targets and meet evolving business needs. Maintenance and operations require a lot of planning, changes require testing, to ensure the performance and accuracy meets our needs. Go ahead. So to catch up on last year's updates, 2024, fourth quarter last year, software release included a change for station owners and managers where they have to now assign a smog check or safety systems inspector roles within the software. That was sort of a cleanup change after the safety inspection rolled out. Some stations, they may employ an inspector with both license types, but they may only want them doing safety inspections, for example. And this change accommodates that. It did not change the fact that BAR still has to assign the inspector to the station. Other changes included updates to the BAR OIS user guide. We call it the online help. Explains how to use the software, just so it's kept in sync with the software. And then lastly, improve the registration and download web page. Users were having trouble finding the last button that disappeared off the screen, so we consolidated the look and feel of that website. Earlier this year, the 25.0 and 25.1 software releases, a lot of effort went into changing the logic to support the next generation data acquisition device. That's our OBD scan tool. So once we have that device in-house and it's completed bar certification testing, then that functionality will appear in the software. It's only there right now to support our certification testing effort. Besides all the DAD integration, we added a new warning for Windows 10. So as you are reminded monthly through bar blasts and other messaging, CalViz computers have to use a supported Windows operating system. It's a benefit to the station, so you get the Microsoft security updates so that you don't have business interruption if there's problems with the computer, like a virus, for example. Windows 10 will no longer be supported after October 14th. So if your CalViz computer is not already on a newer operating system like Windows 11, it needs to be. And then lastly is the biometric device that was mentioned in Holly's regulations. There's a new model number for that device. We tested it and it's just a plug and play device. There's no software changes needed for that. The most recent release, 25.2. This one now prompts the inspector to complete an inspection if another inspection is in progress. So what that means is if somebody started a safety inspection, they need to abort, abandon, or complete it before they can start a smog inspection, and vice versa. We also completed a system security audit. So the central database and all the inner workings meet security standards. System monitoring and alerting were updated. And a large effort was completed to move from Oracle X6 to new Oracle X9 servers in our data center. So the next software release, development's starting as we speak. This is the first portion of the build for including vehicle exhaust noise inspection capability for our referee stations. So user interface and certificate purchasing part of that software will be in that build. We're also going to start DAD 2.0 certification testing this summer. And we're supporting DMV's digital experience platform project. And what that means is DMV is basically modernizing their system. So we have to, in lockstep, change some of our digital interfaces and things to sync with their system. The STAR Station Technician Achievement Ranking reporting is moving over to the CalViz system. That should be done the end of this year. And some Dell server upgrades were completed. And then some automation efforts have been completed for supporting site failover. That's when our data center fails. If there's an issue in one data center, we can fail over automatically to another data center. The final software release in the future this year, fourth quarter, would be to complete the build for the exhaust noise inspection. That would include things like the data collection portion of it. There's an API where those electronic certificates would be made available for court use, and those inspection results would be made available on our public website. That's it.
Thank you, Paul. Any questions from the advisory group? Any advisory group members attending via WebEx, moderator?
None.
Have any comments on this presentation?
There are none.
Public comment? Yes. Yeah. Christina? Is it Christina? Sorry. Yeah, please introduce yourself again.
Hello, it's me again.
Yes.
Christina Kubrin, 352 Innovation. So I'm curious with this system, are you going to be doing support for a cybersecurity standpoint, especially with the EVs? Because if you do that with an EV and it's compromised, like that could affect your system, it could affect the shop. So I want to know if you guys are planning to, do something about that.
Right. So our system, we're from a smog check perspective. So we only pull the onboard diagnostic data that identifies faults in the emissions control system. So we don't have plans to delve into the other half of the vehicle's computer, so to speak, for security of the vehicle itself in those areas.
Are you guys sure? Are you sure you're not going to start to, once the smog stuff is gone, what are you going to make your revenue on? You're going to take the EVs. Like, hey, what can we do there? I don't know. I'm just making a joke, but I just wanted to bring that to your attention. And I put together some programs to help the shops transition, and the cybersecurity is a huge risk. And when you have the OBD2 reader, you can potentially infect all the other cars in your shop, right? Because depending on how the virus, and I'm a mechanical engineer, not cyber, but that's a high risk. And so I think that should be a discussion that is starts getting talked about a lot more. And I wanted to bring that up for this. So thank you for letting me share.
Appreciate you bringing that to our attention, Christina. We are working in partnership with other agencies on electric vehicle issues, an interagency effort to advance the adoption of EV vehicles. So this might be an issue we circle back with you on to get a little more information about it for inclusion in that effort. Thank you. Additional comments on this topic? Moderator, any public comments on this presentation?
WebEx is open for public comment on agenda item 6. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a moment longer to see if we have a request for public comment. Seeing no request for public comment, I think we're ready to continue.
Thank you very much, moderator. We will close this agenda item out. Thank you. I promised you this would be a lot shorter on this one. I think I delivered, or Paul delivered. Thank you, Paul. And back by popular demand. Complaint case studies. We've got 2 today to talk about. These are real world scenarios that come to our attention. And I think Bud was at one time asking for kind of, let's open up what is it? I want to say the
little behind the scenes.
Go behind the scenes. That's the best way to express it. And open up some of the things we deal with on an enforcement level. And I think it's been very good for us to do that. A really good suggestion from Bud. And we've used these meetings as opportunities to do so, especially when we're a little light on agenda items, although we were thinking we were light on agenda items until who knew, until we had the presentation two agenda items ago. So let's get to, without any further ado, some discussion on these 2 complaint case studies from Bill Thomas, our Deputy Chief from the Bureau's Field Operations and Enforcement Division. Thank you, Bill.
Thank you, Pat. Good afternoon. And to the advisory group members, nice to see you all again. I was telling I think that I forgot my prop today because my prop was going to be a front end hammer. Oh, it was Dave. Yeah. No, I forgot the coffee cup and I forgot my main prop, which was going to be a front end hammer, because the point I'm about to cover in these complaint case studies is something the Bureau tries to hammer in on every single 16,000 complaints we meet, we investigate and attempt to negotiate a fair resolution each year. It's about funny enough, estimates, authorizations, and invoices. So let's no further ado, let's get started. So in the first repair transaction, On January 3rd, a consumer purchases, I can almost do this one from memory. I just got to see where I'm at on the slides. A certified pre-owned vehicle on January 3rd. On February 6th, the consumer returns to the dealership service department, same dealership, with an illuminated blind spot malfunction indicator. The dealership prepared a no-charge initial estimate to perform a diagnosis and inspection, and the consumer did sign that estimate and authorize it. Next slide. Oh. See, I already went ahead. Authorization to proceed was provided by the customer in the form of a signature on the estimate. The diagnosis and inspection determined an apparent impact to the left rear corner of the vehicle and had damaged the bumper support and radar sensor bracket. Next slide, please. The invoice dated February 18th showed repairs valued at $2,190 were performed at no charge to the customer. 2 additional authorizations showed the repairs were approved by the service writer on behalf of the customer. No, not allowed. Now's when I would be pounding my hammer so on the table. Even if it's no charge, we must contact the consumer and have a discussion of what we are going to do to their vehicle. And obtain their authorization to do it, yes. An additional note stated per sales approved to proceed, indicating the sales department authorized the repairs at no charge to the customer. And we get it. It's a vehicle they sold as a certified pre-owned. They want to take care of their customer and probably a long-time customer, and they always authorize the repairs. But it's never a problem till it's a problem. Isn't that the old saying? And so we see a lot more of this now, and I'll go on and we'll cover it. Next slide, please. Apparently, however, in this, now when it's never a problem till it became a problem. The initial repairs were insufficient as the vehicle was immediately returned to the service department on February 18th. 2 days later, there's question as to whether or not even it ever left the dealership or whether it was taken home and then picked up. That's part of the nuances that we're not going to talk about today. A new no-charge estimate was created to perform additional diagnosis and inspection and authorized by the consumer on February 18th. Again, the consumer signed that. We have a signed copy of that initial no-charge estimate. The second diagnosis confirmed it was the same malfunction as previously identified. It's a note, and this is relevant to the discussion here. The dealership work order copy showed that the data log in the computer showed that the blind spot the warning was generated on January 28th, after delivery of the vehicle, but before the initial attempt to repair. Next slide. A new revised estimate was generated in the amount of $4,391 to perform more expensive repairs. This is where it went sideways, because the consumer is now like, well, you fixed it for me for free the first time. Why are you now telling me I have to pay? And the ARD is saying, well, because our data says that the impact happened while the vehicle was in your possession after delivery of it. But they've already set the precedent fixing it for free the first time. By not following the rules every time, they back themselves into a bad situation. And a dispute arose between the consumer and dealership due to that. Finally, after much back and forth that I will say continued for many months, the dealership subsequently offered to release the vehicle at no charge. Next slide. So, exceeding the original estimate per Title 16 CC&R Section 3354. Before any additional diagnosis or repair is commenced and before any charges accrue. So there's a lot, and we have a slide in here that discusses, well, what's the harm? What's the real problem of going forward and fixing the vehicle if you're not going to charge the customer? One, the regulation says before any additional diagnosis or repair is commenced. It doesn't say whether or not, it does go on to say, and further our charges accrue, but separating that, as we discussed in earlier discussions today, words mean things. And so it's important. you must give them an additional estimate that describes the additional parts and labor and then describes the cost. Next slide, please. Revising an itemized work order. Oh, Zach's got his Teams open. It's all right. See, I should have been like Matt and had, it's more reiteration of it that the Teams popped up. No, I had a, no, my brain just locked up as I didn't do as good a job as Matt and having the slides up here with notes as to why I wanted to talk about this. This is just a reiteration of the same section. Next slide, please. This is one. So CCNR 3354 subsection C, and that's what we wanted to include the entire 3354. Subsection B was on the previous slide. It was just there for continuity and to include the section of the regulations. My apologies for the brain overload there. Designation of person to authorize additional diagnosis, repair, or parts. I'm not going to read the entire section to you, but I think we could all agree it is not the service writer or the used car sales manager. The regulation actually says specifically it cannot be an insurer or it cannot be an employer of the automotive repair dealer or the dealer ARD itself. Next slide. There can be a designation of who can authorize additional diagnosis, repair, or parts. Again, we thought we needed fill and more presentation, so we'll move on from that one. Next slide, please. Next slide, please. Hey, no, just kidding. No, it's all right. Ineligible designees, 3354, Title 16, 3354, subsection, I think C2, or no, D, yeah. The ineligible designees include the automotive repair dealer providing repair services, an insurer involved in a claim, and any employees, agents, and person acting on behalf of the ARD or the insurer. So that's repeating what we said. Next slide, please. So the analysis is pretty clear here. The ARD is required in this transaction to call the consumer in the first transaction and say, look, we're going to, as a customer satisfaction, extension of customer satisfaction and an accommodation, we're going to repair this vehicle for you free of charge because you purchased the vehicle from us. And is it all right with you if we go ahead and perform those repairs? Obviously, we expect that the consumer would say yes. It is not go to the used car sales manager and say, hey, or do you authorize the repairs? Or maybe you have to do that in addition to the offer to repair it for free. And then because in this situation, it appears that because they were generous and provided those repairs free of charge, although there's some question as to when the damage actually occurred, legitimate question, they set a precedent that the consumer expected on the second repair transaction and it fixed it for free. So always, we can't reiterate it enough. The consumer has to be part of the conversation of what's done to their vehicle, regardless of what the cost for that is. Obviously, and especially if there is a charge for it, obviously you have to have their authorization. But even if it's no charge, you need to have that discussion and get their authorization to proceed. Next slide. We'll talk afterwards. Just thank you. Now I got to get the glasses out. Didn't need glasses for the screen. So, okay. Repair transaction sample 2. This one's a little bit more fun. BAR recently reviewed an invoice generated after services were performed under a maintenance agreement purchased with a new vehicle. So the consumer buys the vehicle and through the dealership purchases a maintenance contract that all regular maintenance items be performed free of charge. The consumer took the vehicle in for an oil change, signed an estimate for $116, and that included an oil change, tire rotation, and the standard inspection. On completion of the repair, the consumer signed the final invoice. And I wanted to put this in here because this is a common thing we see. There's an acknowledgement that can be on the final invoice on pursuant to B&P Business and Professions Code Section 9884.9 regarding additional authorization, where as opposed to documenting the authorization for additional repairs with the 7 items, date, time, who you talk to, how you talk to them, so on and so forth on the final invoice, you can just have the consumer sign an acknowledgement that says, I was informed of the notice and of additional repairs needed, and I acknowledge that I provided authorization. That's not the exact verbiage, but it's what it says. So there's not a requirement for a consumer to sign a final invoice. They're just to be provided a copy of the final invoice. Now, business requirements may need for credit card transactions and things like that, or the acknowledgement aspect of the final invoice. But even if we put that, if the ARD has that acknowledgement phrase, 9884.8 and 3354, or is it 3353? Anyway, the regulations require that when an ARD obtains additional authorization, they're required to document that additional authorization on the work order. So irrespective of whether you put that documentation on the final invoice, it has to be on the work order, or it can be electronically attached to the work order if everything's done electronically, as is the case most of the time. We're seeing a lot where there's only an estimate, and then there's a final invoice with an acknowledgement sign. And there's no documentation of when that additional authorization took place. And it's absolutely required. And so that's another, and that only became apparent in recent days. And so it's not part of the slideshow, but it is part of the same transaction. So you get authorization to perform initial repairs, usually in the form of a signature if they're present. If not, there's unique circumstances where you can document it. If the ARD makes recommendations and seeks additional authorization for additional repairs, that conversation and that authorization must be reported on the work order, possibly a secondary estimate or a new work order copy, and then have the final copy on the, and this is because we need to be able to, if BAR or anybody comes in and looks at it, they should be able to look at the paperwork without having to talk to anybody. The estimate, additional work order, additional authorization, and final invoice, and know what took place from start to finish without having to, hey, what, if we have to ask, hey, what happened here? It's probably not correct, and it's probably not compliant with the regulation. So I just wanted to point that out. A signature on the final invoice is not required, but did receive a copy of it. The customer did not receive, yes, you're correct, Zach, thank you. The customer did not review the final invoice until getting home and found the value of repairs was now listed at $222. Again, the consumer did not pay a dime for this. It was done under the maintenance contract. But it now included the cost for the oil filter, oil, and they added an engine air filter. Again, free of charge, but it's the consumer's vehicle. They're probably not going to say no, but they have to be advised. So I don't know, maybe they knock a vacuum hose, and we call it a vacuum hose, but some sort of air tube off the air intake, and now it sets a mass airflow sensor code or something. And the consumer's like, well, wait, why is that code coming up? Oh, you changed my air filter? I didn't know you changed my air filter, really. Not a good situation. And that's what I said in bullet point 2. Next slide, please. Oh, I'm supposed to be reading from here. And again, we want to reiterate before any additional diagnosis or repairs commenced, or before any charges for labor accrue for labor or parts. Charges accrued even though the consumer didn't pay for it. So this transaction, it still begs the question, well, what's the harm here? And that's on the final slide. Zach. If there's no cost to the customer, why is notification and authorization important? So it's the customer's right to make decision as to what work is performed on their vehicle. Failing to notify a consumer of goodwill repairs establishes an expectation of future no charge repairs. If a malfunction occurs as a result of the repairs, liability becomes a question. Slippery slope. So if no charge repairs don't require authorization or notification and authorization, why not $20? Why not $40? It's only $20. It's only $40. It's a very slippery slope and that the bar doesn't want to see take place. And then finally, CCNR 3354. There is another slide after this one, but 3354 requires notification and authorization for any repairs not contained on the original estimate. Simple and short, it's the law. It's the requirements of our regulations. And it protects all the parties. And final slide, and this is really the message here, and I'd be pounding the hammer again. A lot of complaints to bar involve a lack of effective communication between the ARD consumer. There was not, both parties didn't understand what was going to take place. And if we practice good communication, following the best practice of always notifying the consumer of suggested repairs, supports good, effective communication, and keeps everybody happy, so to speak.
Thank you, Bill. Very well done. Comments, questions from the advisory group? I saw Bill, Bud again, and Dave.
Just two things real quick. The first one was on the first example, they tried to diagnose what happened with that sensor, the blind spot sensor. And I think it was like $2,400 and when they're on that one and then they didn't fix it, come back $4,300 and blah, blah, blah. It bothers me a little bit. They couldn't find it the first time. Okay. They should have had a first fix. Good diagnosis, good fix, the first go, right?
What I can say happened and why it's important that a conversation should have taken place is they attempted to replace a bumper support and the mounting bracket for the blind spot sensor and have that fix it up. It didn't work. So now they had to go in, pull the bumper, send it over to the collision shop and repair it correctly. All new attaching hardware, make sure everything was straight, do a proper calibration and so forth. So the first repair was almost a superficial repair, which would have been appropriate to have that conversation of this may not fix it, but we're doing this one at no charge. But we do suspect that maybe this happened after you took delivery of the vehicle. And now it's all out in the open and there's no surprise instead of trying to bring it up later. So,
Yeah.
but excellent catch.
Yeah. But on top of what you were trying to say, that one kind of bugged me a little bit too on that one.
Right.
And then the second comment is neither one of these had any towing issues, right? Sorry.
But even if they did, I don't care.
It's not on the invoice.
Dave.
Hey, thanks, Bill. So what, if any, enforcement took place on both of these complaints?
The first one, and this is our education is enforcement mantra. We educated the ARD. The intent was in the right place. And so, there's no intent does make a difference into what enforcement action we're going to take because they were just trying to take care of their customer. Had they done things properly, this transaction probably would have never gotten to us. And instead, and trust me, I can't over exaggerate how far sideways this transaction went. As Pat nods his head because the intent was honorable, if you will. So we just educated them. It's for your own protection as the ARD. Have those conversations, document it. And again, we should be able to look at it from start to finish and figure out what took place. And we could do that on this one. It's just when we start seeing sales managers authorizing it and service writers, that's where the problems arise.
In the second one?
There was some education as well.
Okay, so both education.
Both
Good.
of them are education.
I figured that was the answer. And,
Yeah,
and
it's.
as a shop owner, I appreciate that. Yeah, I mean, obviously, I think that mostly, no money changed hands anyway. So the intent was to move it along, keep it going. Unfortunately, it went sideways because, as Bud says, write it down for God's sake.
Right.
Thank you.
Yep.
Anyone else? Yeah.
So there are a lot of transactions that probably a few in the room see with third-party payments on maintenance, like the fleet leasing programs.
Yes.
Like Dahlman, MK, and a bunch of other ones. So those are kind of interesting when you read the authorization requirements in 3354, because some of those don't always fall in that normal scenario, because the person presenting the vehicle, we don't know if this vehicle is owned or leased. Obviously, if the vehicle is owned, because these companies actually handle maintenance programs for both owned and leased vehicles, right? So if it's a leased vehicle, this company doesn't technically own it, the leasing company does. So we put in the information into the maintenance provider puts the information into their portal, and that says, hey, service the, do the oil change, replace the air filter, and do a fuel filter. So if we go back to in a good practice would be to, like you said, communicate on the back. You go back to the person driving the vehicle. Oh, hey, it says we need to do this. They're authorizing us to do these 3 services. But if those services are done as authorized, it's actually not the driver or as the way it's defined as the customer is defined as the person presenting the vehicle for service, right?
Right.
So technically, the person presenting the vehicle for service isn't authorizing those services.
Agreed. And Zach, can you go back to slide 9? So in that scenario, the customer would need to make a statement, say, I'm presenting this vehicle, but I won't be authorizing repairs because the lease company is who authorizes the repairs. ARDs, and this is another thing that we don't see used much as often as it should be used, is a designation of person to another person to authorize repairs. And so I would think that might actually work very well in this situation, but I'll be honest with you, I don't think it's used very often in this situation, but I think it should be. And I'm now adding it to the presentation that if you're working on something that's going to be paid for by a third party payer, or say the non-owner of the vehicle drops the vehicle off on behalf of the owner, but they tell you to call the owner to get authorization, and there's other scenarios kind of similar to that we've discussed in the past.
A lot of those are business to business, like a commercial transaction, right? So wouldn't that be different maybe?
Yes. I know one of my automotive program managers in the back just cringed when you said business to business. Because business to business is technically not regulated by us, but there's also qualifying factors of continuing business relationship.
Yeah.
And I think in the example of a lease company, and it depends, because there's also, and I don't know if this still exists in industry, and I'm going to date myself how long I've been out of it, but when I was in industry, we used to have national accounts.
Yeah.
Where various leasing companies would pay the bill and authorize the repairs. And so that person would just drop it off and they would sign.
Yeah.
But then you would talk to the leasing company, and then the leasing, that's probably a business to business, because it's a contemplated and ongoing relationship for the certain repairs. So the business to business scares us at times because,
yeah, and it's generally in those cases, I would say, I think the services are usually recommended, and the leasing or maintenance companies are usually denying services that sometimes the person presenting the vehicle wants, and then it becomes an argument like, well, I need wiper blades, they're not working.
Right.
And then so usually not the other way around. It's usually not where the example where you're doing services that, that they authorize that as the person presenting. Anyway,
excellent. Great points.
I will also point out that I think it's estimated by 2035, which is 10 years from now, that like 60% of the cars are, maybe not that many, but it's a very high number of cars are going to be managed by leasing and maintenance companies, just because, young people, they want to subscribe to these vehicle subscription programs where you don't have to own a car. You can just
You just call for
Yeah.
a ride. You use, yeah.
Yeah, or you can
You
use
go
a
in
car.
your app and
Yeah.
have somebody pick you up and
Yeah.
take you to Home Depot and,
Yeah.
uh,
Yeah, car sharing. The designee thing, yeah, so, definitely not used often enough, and, in Matt's case, right, I mean, might be a good idea.
it might not be,
Maybe,
but
maybe not.
it may or may not be a good example because it is a business to business under the leasehold agreement. So,
Yeah, but
they're
Jack,
truly the owners of the car, but
Jack can support me on this. It's like, the student is here and mom and dad own the car. Mom and dad are paying. Student drops off car. Mom and dad refuse to pay.
right.
Right. And so, so mom's paying. Okay. Authorize that.
Right. Exactly. Yes.
Yeah. Because Jack probably gets that call 10 times a year.
That's the one I was referring to. That
Yeah.
we hear that one frequently as well.
Other comments? Let's go for public comments on this here in the room. Yes, come forward, please. Thank you. I haven't seen you yet today. Feel free to introduce yourself.
Sure. My name is Sam Noriega, and I'm a smock shop owner.
Okay. Sam.
I noticed you mentioned the word intent, and you guys take that into consideration.
When determining the appropriate enforcement action in any case, and again, enforcement runs from education to formal accusations. And that's a wide spectrum, very wide spectrum. So we take a lot of factors into consent. We take past behaviors, past notifications, what was the intent in this transaction, and there's just many factors. So.
And just out of curiosity, who makes that determination? Is that the bar rep that comes out, the first one? Or is there a collective group that makes that determination, or who determines if there is intent or not?
The discussion of what takes place for enforcement is usually between the bar rep. Most of our experienced reps know and can apply our policies appropriately. Those that are still learning the laws and regulations will often consult with their supervisor. But it's a collaborative effort internally, and we have a lot of discussions and a lot of direction that go out. So, and again, I know I mentioned intent. You're making me regret it. But it is a factor. I mean, we would be lying to say that, because in that transaction, the intent could have very easily been that they didn't want to have to bother contacting the customer and taking the time to contact a customer. So the intent could have been laziness, and that would have led to a different outcome, quite likely. So.
Absolutely. Just wondering if it was one individual, if there's a collective group that made that decision, because one individual, individuals vary from person to person big time. Thank you.
Thanks, Tim. Yeah, Christina.
Thank you.
Hi there.
Hi, it's me again, Christina, 352 Innovation. This is more just something I thought of with that discussion. What if the customer, okay, so they drop off the car and they're like, all right, cool. And then they get in an accident or they have a heart attack and they're completely unable to authorize anything, but have not designated anyone to do that. So is there something in that other rule that allows you to cover that? So yeah, that conversation you had just
She's encouraging me. Technically speaking, in the purest black and white interpretation of the law, if that customer hasn't designated somebody else to authorize repairs, you shouldn't be seeking to get authorization from somebody else unless so designated. And I know regular ARDs are not getting the power of attorney, but I think that's an excellent example of the last question in that that's a very unique scenario that we don't have regulations for or even policies or procedures of how to deal with. And we're going to look to, okay, what did the ARD do? I'm not even going to propose suggestions because they tend to be followed by when I think out loud at these meetings. I would think that the ARD is going to communicate with somebody else on who can act on behalf of the consumer and figure it out. And figure it out looks like, I have no idea, but I would expect that going back to intent, there would be an intent to kind of figure out, okay, what do we got to do here? It's a horrible situation. This person has had a tragic event take place, and now we have this car. Maybe the decision is not to proceed with any repairs, or maybe you've done some repairs and you don't proceed with any further repairs and have it towed back to their house until they can. And I said I wasn't going to hypothesize on a solution, and I did it.
I never thought of it even in the first place.
Um,
For all that other stuff.
Well, yeah, we,
It's all right.
okay.
I'm here to help. Thank you so much.
Thank you.
Thank you again, Christina. Anyone else in the room? Moderator, can we open it up for public comment on the WebEx?
WebEx is now open for public comment on agenda item 7. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, I would. Thank you. We will close this agenda item out and move to agenda items number 8 and 9, combining those as we have in the past. These are just handouts. They're quarterly updates on statistics for the 2 programs, enforcement and our licensing programs. Any comments regarding any of the material that was in those 2 handouts? It's not an actual presentation, it's just handouts. No one in the room. Moderator, could you ask for public comment on agenda items 8 and 9, the 2 handouts?
We are open for public comment on agenda items 8 and 9. The handouts were located on the BAR website. If you'd like to make a comment, please raise a hand by tapping that hand button. Dial-in users dial *3, and we will call on people in the order we have requests. We're going to spend just a moment now to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, thank you. All right. Agenda item number 10, public comment for any items that were not on today's agenda. Anybody here on the advisory group? Not seeing any hands. Anyone? Yes, Sam, please come forward again. This is a hard agenda item to wait all the time for, as you have. So I appreciate your patience in getting to this agenda item. Okay. There's a button at the bottom that's okay.
It's vital.
Again, the introduction of your name and it's Sam. What was the last name?
Noriega.
Noriega.
Yeah, so I'm just going to read this letter I put together. Hello, my name is Sam Noriega. I am a smog shop owner and also a business solutions analyst lead. I'm responsible for designing software modifications to systems in the pharmaceutical supply chain that ensure medications you receive are legitimate and acknowledged by the manufacturer down to the bottle level. In other words, there are extensive scans and verification steps throughout the flow of product. From the moment it enters the distribution center to the moment it leaves, lives depend on that process, and we work hard to close any gaps that could put the patients at risk. What brings me here today is a concern. Excuse my voice. Not only for my livelihood, but for the livelihoods of the technicians who work in my shop. I once believed the bar enforcement efforts primarily targeted shops knowingly performing illegal smogs. But over time, after reading through various accusations, I noticed a trend. Some, not all, seem to result from honest mistakes. Yet the outcome was often the same. Shops lost their licenses. That was alarming. I immediately implemented best practices to avoid that fate, especially as a high volume shop serving Californians who rely on us to stay compliant and on the road. But after a deeper analysis, I realized that no matter how strong our internal processes were, there's one component that we can't control, which was the OIS software itself. I want to raise awareness of a specific gap that I believe the software can help close. Let's start with the happy path. When everything goes according to plan, a customer arrives, we sign them in, scan the badge, or scan our badge, palm, scan the vehicle and paperwork. Enter the certificate type, engine, family, and mileage, acknowledge the vehicle information, plug in the data to pull the vehicle data, perform the visual inspection, and scan our palm again to complete the test. It's clean, safe, and a verifiable flow. But sometimes the vehicle won't communicate with the machine. It must be moved to another bay. In a busy environment, the original session might be still active. A new vehicle could be connected without realizing the previous session wasn't closed out. In that moment, a technician might unknowingly pull data from the wrong vehicle, even if unintentional. This can be classified as clean plugging, and the disciplinary consequences are severe, including potential license revocation. That's a high-stakes result for what it is. At its core, a preventable process gap. What I propose is simple but powerful. Have the OIS require one final VIN scan after the data pull. Just like the final palm scan, before issuing a certificate. If that VIN doesn't match the original system, the system would abort the test or at least alert the tech at that point. This safeguard can prevent honest mistakes from being misclassified as misconduct and allow bar enforcement to stay focused on true bad actors. I include a screenshot of what it might look like. I have a screenshot here of what it looks like, but it's basically just scan the VIN right after it pulls the data. That way it can match up with the initial VIN scan. If this isn't the right form for this suggestion, I'd be grateful for guidance on where I can formally submit it. My team and I are committed to doing things right, and we're also eager to help make the system even stronger. Thank you for your time.
Thank you, Sam. It was really good. Did you have something you want to give to me or one of the staff? Yeah. And I'll make sure it gets to all of the people it needs to. Was there pictures you saw?
Second page is a picture. Just a screenshot.
Oh, I got you. Perfect. Thank you. Good job. Oh, well, is there a copy machine in this room or something? What is going on? What's going on? He came prepared. Yes. He had multiple copies. Very good. Well, do you want this copy back? Did you go? I'll keep it. Okay. You have multiple. Okay. Good. Thank you. Very good idea. We'll see what we can do. I don't know. Very well prepared too. I appreciate you coming in with that letter you read. Yes, Bud.
Yeah, just a quick follow-up. The format of these kinds of get-togethers, that is an open environment from people who are vendors, regulators, shop owners, and that kind of thing, leads itself, and it should, to having a fair dialogue. And you coming in with an open idea like that, I think is fabulous. I think that's really what this is about.
Yeah, really good. Thank you for reiterating that, Bud. Additional comments, public comment for any items that were not on today's agenda. Moderator, you can open it up for public comment on agenda item number 10.
WebEx is open for comments for items not on the agenda. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. As a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to take just a moment longer to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, thank you. All right, agenda item 11 is really just an announcement that our next Bar Advisory Group meeting will be on Thursday, October 23rd, 2025. It is subject to change, so always take note of the fact that an announcement later on as we get closer to that October date could suggest a different day. But right now it's tentatively scheduled and on our website listed as October 23rd. Any questions or comments about that? I should be in this room. Okay. Yep, and that's another important note is we might tell you this room and we might get bumped for other priorities with other programs at the Department of Consumer Affairs, but for now it is tentatively scheduled for this room. And agenda item number 12 is our adjournment. Before we do, I want to say thank you to everyone, all of our presenters, our advisory group members, great dialogue. My apologies for running longer than we ever thought we would, but there was a significant amount of discussion on whatever agenda item it was, agenda item number 4. And that was a good dialogue, and I'm glad we had that discussion. So I'm not apologizing for the fact we ran over, because I think we needed to have that open airing out of issues and thoughts and concerns about the new regulations. So thank you very much for doing that. Thank you to all of our support, Bryce, with your support, David, with your support on the WebEx, and of course, Zach, helping us advance the slides and so forth. And appreciate that. Have a great rest of your summer. We'll see you in October. We are adjourned.